May I please give me look. Lordship, I would like to mention one CRP IE for orders, Lordship, and next is Lordship.
Okay. 18th March.
Okay, Lordship.
But this is an RSA of 2022, but original case is of 20 years old. So it may kindly be listed day after tomorrow for hearing. It was already
Orders
hearing
column.
list.
Yeah, orders column.
Orders.
First, it will come in orders column.
Great, Your Lordship. Lordship, I would like to mention this IA 445/2026. Lordship, already we have taken step. In the meantime, the claimants have complained to the IRDA and all that, Lordship. So can it come tomorrow, Lordship? We can take some step to deposit the amount or something like that.
Or orders.
Orders, yes, orders. Highly applied.
May it please Mr. Lawson, my lord. My lord, matrimonial appeal, my lord, amicably settled between the party in the mediation. I'm praying for listing on my lord 17, my lord.
Okay.
Obliged, my lord.
May I please, Lordship? Lordship, I beg to mention item number 13 of court number 9. Lordship, the matter is deferred for today, so Lordship, fixed date may be fixed.
No, registry will fix the date. It has been notified that all the matters are deferred. Registry will give a date.
No, please, Lordship. Lordship, I beg to mention one arbitration appeal to be listed tomorrow.
Under
Appeal,
which column?
motion. For motion, Lord.
When have you filed?
Today itself, Lordship.
Then it will come day after tomorrow.
Day after tomorrow, Lordship.
No, it will come in its usual course. Within 2 days, it will be listed. If it does not get listed, only then you have to mention.
Actually, tomorrow, if may list the matter, it's of a little urgent matter,
No,
Lordship.
no. It will otherwise be listed within 2 days. If it does not get listed, then you mention.
May please, Your Lordship, item number 19. The senior engaged counsel is indisposed for the day, and we have also consulted the appellant. Kindly fixed another date.
What is your name?
My name is
Item number 19 of this court. What is your name?
Arknav Rajkwa. I am representing and
What is your name?
Arknav Rajkwa.
R.
Arknav Rajkwa.
R. A. Rajkwa. You are appearing on behalf of?
Manik Chandra Datta. The
But-
respondent.
You have informed the other side.
Yes, sir.
Had Mr. A. Rajkwa, learned counsel, appearing on behalf of learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent.
Lordship, Lordship, next Thursday.
Let me dictate the order. He submits that he has intimated learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed. 24th of March. Yes.
May I please, Your Lordship? Lordship, I beg to mention for listing of IAS Bill 114/2026 in one RSA matter, Lordship. Lordship, what happened is the matter was listed yesterday before the court number 25, but I being the conducting counsel was on lag before another court, Lordship. So the matter went unrepresented, and there was a point regarding extension of interim stay of execution.
What was the order passed by the court?
Order for listing it on 6/4/2026, Lordship. That was the short order passed.
Whether the other side counsel appeared?
No, Lordship, because as per the earlier order, we were directed to serve notices by routed through the registry.
When you want listing?
On tomorrow, Lordship, because there is one point regarding interim stay, and that cannot be extended, Lordship, because the matter went
Okay,
unrepresented.
okay, tomorrow.
Tomorrow, Lordship. Much obliged.
May I please, Your Lordship, I beg to mention listing of 2 MFAs in the second week of April for orders. Much obliged.
May it please Your Lordship. I beg to mention item 21, madam, of the daily list.
Yes, what is the prayer? What is the prayer?
For adjournment, my lord.
On what ground? You have informed the other side.
Yes, Lordship. I am for the appellant, Lordship. Lordship date may be fixed, Lordship.
Heard Mr. A. Dekar, learned counsel for the respondent who prays for an adjournment. Also heard Mr. A. Barwa, learned counsel for the appellant who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed
Lordship, may kindly fix on 23, 24, Lordship. Any
of,
date, Lordship.
of March.
Lordship.
27.
Lordship is a succession method, Lordship, succession appeal, Lordship.
My lord. 27, my lord. 24, some difficulties, my lord.
24, Lordship.
31st, no, we have our own cases fixed. So,
Succession advocate is there, Lordship. He's some other case on 24th, Lordship. So may kindly fix on.
then you have to take risks if
Yes,
it does
yes,
not
Lordship.
reaches.
Yes, Lordship.
Okay, 24th.
May I please, Your Lordship?
Must-
May I file an additional affidavit in item number 4, ma'am. That may come on record.
Okay.
May I please, Your Lordship? Your Lordship, I am praying for listing of an MSc appeal in order column. The appeal was not listed since last.
When you want.
It can be listed on, it will come on order column, so it can be listed on 17th also.
Okay.
Oblige, Your Lordship.
My lord, you are again traveling, my lord. You just place, my lord, because they yesterday argued the least pendency. Now we have just obtained the certified copy of that original suit, where we against the defense respondent number 2, it was proceeded expert. So just to clarity, for a clarity, my lord, you just place the certified copy of the order sheet.
Against defendant number?
Vendor.
Vendor. So,
So there is no
So-
notice.
so he was not aware.
Yeah,
aware.
that's for that clarity, my lord, because they have said that on 5th of December, they have filed the suit. On 7th of January, the registration was took place. So therefore, lease pendency. So the order sheet clear, my lord, that it was proceeded ex parte. That therefore.
And I am submitting also the order sheet, not a certified copy, that notice was served upon him. And 2 judgments on the issue of limitation in such cases.
You have marked the paragraphs.
Mark the paragraph.
Mark the paragraph number.
I'll submit.
No, grateful.
Obliged, ma'am. And just hand over to the.
You also mentioned it is by respondent.
Yes.
Some indication that this judgment is given by respondent.
For referral to special mediation drive, item number 1.
Yes.
This matter may come for hearing also.
Why it cannot be sent for mediation?
My lord, if I'm,
Yes, Mr. Day.
my senior colleague is there, my lord, otherwise. My lord, I had given this matter for pre-settlement, my lord, and on that time,
You are
I am for the
the
respondent number 1, my lord, in this case.
respondent. Who is respondent number 1?
That is the claimant in this case, my lord.
Okay.
Satyakam. My learned senior is there otherwise, but I was also
No,
given.
actually, I was not informed that, yes.
I also do not know, my lord.
They only, I came
Oh,
in,
So,
filed the.
That issue you
that is
resolved
a separate
along.
issue, my lord, if I may address on it.
Just, only 2 days ago, I came to know that yes, it be.
No issue.
Actually, initially, I was contacting the case.
I'm just.
Both of you may submit.
Yeah.
Fine, obliged, my lord. What I'm just submitting is this, my lord. I had given this matter for pre-settlement. And during the pre-settlement, the insurance company that is United India had, their officers had told me that this case, and there was another analogous case. 2 cases can be taken up for settlement. So accordingly, I had thereafter spoken to them. They said, we will find out the file and Mr. Day, we will communicate with you. So, if my learned
Otherwise,
colleague can-
you are agreeable. Why this appeal has been filed?
Insurance
One time,
company
as well as on driving
Oh.
license issue, the victim who was driving a 2-wheeler vehicle, his driving license was not valid. Earlier on, another advocate was there. I am engaged later on from the, for the appeal in this case.
He already expired.
No, if there is some hope, we may send it.
Yes, my lord. What I'm saying is this, my lord. The issue, if my learned senior permits me, is this, that driving license of the victim is one of the issue.
Yes, yes.
Whereas the offending vehicle's driver's license is not in under question, my lord. That is Absolutely. No, my lord is aware of the law in this part. I do not want to trouble this.
And
honorable
you
court
are
with
the, you are the insurer of the offending vehicle.
offending vehicle. Offending vehicle's driving license is not in the question.
And the tribunal held that he was negligent.
Yes, yes.
Then that license is of no relevance.
Relevance, my lord.
So appeal was on that ground, it was filed by some other.
No, then give a try in,
If everybody is agreeing, then probably my lord we can.
He has talked with a company. I have no instruction actually. Then matter may be sent for conciliation.
mediation or lok adalat.
Mediation it is.
Mediation.
It is a
Or
pre-mediation trial.
if that can be sent to local, by the
Yes, yes, second of all.
if it can be settled in the local, then nothing like it, sir. If it is, if it is convenient to everyone. Otherwise, mediation also I am ready, but does that the case is little old, my lord, of 2019, like
Heard
MSc appeal, my lord.
Mr. A.J. Saikya, learned counsel for the appellant. Also heard Miss, what is her name? J. Paul as well as Miss A.B. Day, learned counsel for the respondent claimants. After hearing learned counsel for both the parties, it appears that there is an element of settlement in this case, and both the parties are agreeable to referring the matter to the ensuing Lok Adalat on 14th of March.
14th of March.
14th of March. Let this matter be listed accordingly before the Lok Adalat. The learned counsel shall, or both the parties shall intimate
Clients for.
the appellants and respondents,
My lord.
because time is very
Yes,
short
my lord.
to remain present before the Lok Adalat.
If I may be, my lord, there is another matter also of the out of the same analogous case. That my lord, my Abdul Uddin Mazumdar, that case number I will give it out of the same accident.
That is not before us.
My lord.
Obliged.
My lord.
Admission, item 2 and 3.
Yeah, please, your lordship. Lordship, may kindly take up item number 3 first. It would be easy for me to.
My lord, I have put a respondent, my lord. The earlier date, I have made a submission that some settlement is possible, my lord. But as per my instruction, my lord, it's not possible now, my lord. So the possibility of settlement is not there. But my lord, today I have some personal difficulty, my lord.
Lordship, it is pending. Let me finish my argument because he had taken time, quite some time.
Let us, what personally?
Some medical emergency is there, my lord. So
When will you be ready?
after 28th March, my lord, any date, my lord.
Any date, okay, if he's for medical emergency, I cannot.
Any date after 20th March.
After 28th March. No, iman dikhol na. Shorter date before Bihu. 2nd of April will be your.
Thursday, your lordship, 2nd of.
Heard Mr. A. Bishwas, learned counsel for the.
Tomorrow. Lordship, my assisting counsel, Mr. A. Das, would be tied up on 2nd.
Learned counsel for the appellant / petitioner. Common order of both.
Lordship, can it be on 7th then, your lordship?
Okay.
Because
Also,
though I am
Mr.
free, Mr. A. Das would not be available.
Learned counsel for the respondent, who submits that, who prays for an adjournment on the ground of medical urgency. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listed on
7th of April.
7th of April.
Yes, sir.
Orders, item 5 and 6.
No paisi to give.
I'm for respondent, lordship.
There was
Respondent 1 and 6.
Well, in this case, we have filed against the judgment and order dated 18th.
Why it is in orders column?
Well, here, my lord, another appeal has been filed by the insurance company.
Service is not, not yet complete.
It was not 6 of.
I appear on behalf of the insurance company, but engaged counsel is out of station, Lordship. Item number 6.
No, why it has come up for in orders column?
In last order, it is reflected to take a step by the petitioner, my lord, in item number 6.
It says that appearance of party is complete. It should have been listed in hearing column. Otherwise, it is ready for hearing.
But Lordship, in item number 6, they are supposed to give us a copy. Till now, they have not given us a copy.
Item number 6.
And 5 also, they have to give us a copy of memo of opinion. Naik po. DD pa. Nahi, nahi. I ekhon asil, delay. Ekhone ase.
I'll provide, ma'am.
In both the cases, memo of appeal is not given to us.
Otherwise, in item number 6, whether an appearance of the parties is complete.
Very good, ma'am.
98640
In item number 6, who is the appellant?
096.
Who is for the appellant in item number 6? United in. Okay. And who is for the respondent number, claimant respondent?
Claimant respondent, I think he will.
I can appear, ma'am. 1 to 3, my lord.
1, 2, 3. 4 and 5.
4 and 5. I am appearing for Oriental. I do not know what is
6.
6. Then I am appearing for 6. Lordship.
Why both these matters are tagged together?
Because one is filed by the claimant, another is by the insurance.
Arising out
company.
of
Two
this-
vehicles, Lordship.
Arising out of the common judgment.
Same judgment. I think
My lord,
same.
same.
Put that copy and I do. Same judgment eh hobo.
Copy টা আমাকে দিব আমি
Na call din na.
বুঝিও
Phone hoy aso ke? Rishikesh Bravo. Secretary data admin administration. Rishikesh Bravo. H Bravo.
বুঝিও কপি দিব আমি আমি একটা তো হেয়ারিং হলো
Who is appearing for respondent number 4, 5, and 7?
my lord, copy of that petition is not, memo is not along with me, my lord.
Then you take steps. Let them.
My lord, I am for the 5 petition.
You are appearing for the claimants only.
Petition number, petition number.
Yes, I have to take step, I suppose.
Well,
Lordship.
They,
The
they,
insurance.
Item 6.
yes, you take steps. In item number 6, Likhibo, heard Miss, what is your name?
H. Bravo. H. Bravo.
H. Borua, learned counsel for the appellant. Also heard Mr. D.
PK Bora, my lord.
BK,
PK Bora.
PK Bora, appearing for respondent number 1, 2, and 3, as well as Miss R.D. Majumdar, appearing for respondent number 6. It appears that the notice to other respondents, namely respondent number 4, 5, and 7 have not yet been issued. Issue notice to the aforesaid respondents. The appellant shall take steps for issuance of notice upon respondent number 4, 5, and 7 by speed post as well as by usual mode within 7 days from the date of this order, returnable on Putul date at the date. Be attentive in court. 1st of April.
The copy may be given to us.
The appellant is directed to furnish the memo of appeal and along with the annexures to the learned counsel for respondent number 6 as well as respondent number 1, 2, and 3 within
And in 5 lordship, the
I'll provide.
appellant will provide.
within a week from this order. In item number 5, heard Mr. P.K. Bora,
My lord.
learned counsel for the appellant. Also heard Ms. R.D. Majumdar, learned counsel for respondent number. You're for Oriental
Yes, lordship.
respondent number 3. And Miss D. What's her name?
It's Burra.
H. Bora. Appearing for, you are for United India Insurance.
Yes, lordship.
Respondent number 6. Though it appears from perusal of the record that by order dated 21/1/2026, it was observed by the court that this case is ready for hearing. However, learned counsel for respondent number 3 has submitted that she has not yet received the copy of memo of appeal along with the annexures. Learned counsel for the appellant is requested to furnish the memo of appeal along with the annexures to the learned counsel for respondent number 3 within the course of the day. You have to,
By tomorrow, I'll.
within 2 days from the date of this order. Please this matter, 1st of April.
I'll oblige, lordship.
Oblige, my lord.
Lordship.
7, first of April.
Just I take some indulgence, lordship. Item 8 and 9 hearing, I'm ready to do, and 11 also. I have another matter in court number, that is for orders. I'll do that and I'll come and do these cases. I'll
My lord,
oblige.
this will come on 1st of April.
1st of April.
Oblige.
May
One
it please your
item.
lordship. The matter was fixed for hearing in the last date as per order 27/2/2026.
Why this high?
Your lordship, they have filed the IA, the claimants for stay vacation. So in the last order,
When is it is fixed for hearing?
your lordship, the date was
MEC
today, I believe.
appeals, huh? Maybe. We'll fix it for hearing, Mr. Insane.
In the last occasion, today was 16th also, yes, yeah. But
No,
I think
no, in the appeal, no date of hearing has been fixed. It is only mentioned that
related to.
okay, but it has been listed in orders column.
I think the order was passed in his case, you know.
Yes. We'll fix a short date for hearing. What is the issue?
Your lordship, we have filed this appeal against the order of the learned commissioner, where we were not implemented as a party, and against us, the award was passed. So that is why we have filed this appeal.
Hearing
That
their
is the
case
main
is that the commissioner passed the order, your lordship, without giving opportunity to them. It was their case, your lordship. But in fact, your lordship, no such opportunity was given to them as well as the applicants also here. And it was passed on the basis of the report submitted by the respondent number 2.
Okay, we'll fix it for hearing only.
Your lordship, the award was passed against us, not against them. So that is why we have filed the appeal.
Item number 7. MFA order could be. Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. A. M. Khan, the learned counsel for the respondents. Though by order dated 27/2/2026 passed in the connected interlocutory application number 3487/2025, it was directed that this matter could be heard on the next date, and the said interlocutory application was directed to be listed along with the MFA. However, today this matter has been listed in orders column instead of hearing column. Accordingly, the registry is directed to list this miscellaneous first appeal for hearing on which date?
April year.
13 April. 30 April. Okay, 30 April.
Item 24 from supplementary list.
My pleasure also. I is for the convention of delay of 38 days. Perhaps the notice has not been served. So the name is not shown in the court list.
You have taken steps.
But on last occasion, there was a direction to take steps. Probably we have missed it. But I
You take for
Yeah.
fresh steps. But Miss,
take this case along with this 49918 arising out of same accidents. MSAP number 499 of 2018.
which photo? It is not listed today.
Not listed today, Lordship. May tag along with this case.
Not Mr. J. Kolita, learned counsel for the applicant. It appears from office note dated 10/3/2026 that the applicant has not taken steps for issuance of notice upon respondent number 1 and 2, as was directed by this court. Stop. Learned counsel for the applicant prays for giving one more chance to take steps for issuance of notice upon the respondents. The prayer is allowed. The applicant shall take steps for issuance of notice upon respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. Let this matter be listed along with
MSC appeal number
MAC appeal number
499 of 2018.
499 of 2018.
Loss.
Item 25.
May I please, Your Lordship? Your Lordship, the appeal has been admitted and the cross objection has also been admitted. And as per the office records, as office notes, the LCR has been received. As such, the matter may be fixed for hearing, Your Lordship.
Yes, it is ready for
Ready
the
regarding service and.
heard, miss. What is your name?
Ardas, on behalf of
Ardas, learned counsel for
Thank you,
the
Lordship.
appellant. Also heard Mr. D. Mandal, learned counsel for the respondent as well as the cross objector.
Yes, 1 and 2.
Stop. It appears that these appeals are ready for hearing. Accordingly, list
Your
this.
lordship, can it be listed on 30th 30th April.
April.
Highly obliged.
Item 26.
Dates, दिन पे. One.
This appeal may be placed before the local adult. Already matters is compromised outside the court.
Matter has been
Compromised.
coming look Adalat.
That's it.
Day after tomorrow.
Day after tomorrow. That's it.
Notice.
No, already they have appealed. That's it.
Heard Mr. B. Chakravarti, learned counsel for the appellant. Also heard Mr. K.K. Bhatto, learned counsel for the insurance company. It is submitted at bar that this matter may be amicably settled between the parties, and therefore a prayer is made for referring this matter to the ensuing Lok Adalat on 14th of March 2026. Stop. Accordingly, let this matter be listed before Lok Adalat on 14th of March. The learned counsel for both the parties are requested to inform their respective clients to remain present before the Lok Adalat.
Item 27.
Please, your lords.
Please, your lordship.
Lords, this is IA 2022 of 2025, lords.
Whether Mr. R.C. Sancheti is engaged in this case. This was not informed to me earlier. I cannot take up this matter. You should have informed me day before yesterday.
Your lords, he's been recently engaged, your lords, if your lords, it's a part third matter. Mr. Sancheti has recently appeared in this matter, your lords.
I'll be arguing this matter, my lord, all through the, if your lordship considers that.
No. It may not be proper. It will be listed before another bench.
Your lords, I have no objection, your lords. I'm just saying because it's a part third matter, your lords.
No.
Mr. Sancheti has recently come into this picture.
No, it is not proper. It will be listed before another bench on Monday or any other date of your choice. You may choose the date.
Can be taken on 20th of March.
Your lords, I'll suggest like as soon as possible. 16th is fine, your lords, because your lords, now I don't have any, I really can't make any submissions as of now, your lords, since your lords have expressed their opinion.
20 March is okay.
20th March, your lords. Your lords, 20th March won't be possible. Your lords, can it be 16th only as suggested by your lords?
16th March.
Lords, this is anyways, your lords, been pending since long.
Okay. Stop. Heard Mr. B. Chakravarti. No. Today your name is not reflected. Mr. Goenka.
Yes, your lords.
You are appearing in which IA?
Your lords, 2022, your lords.
Lordship, the name of the local council is engaged. I'm appearing for M. Sarewan.
Not Mr. R. Goenka or
N. Goenka, your lords.
N. Goenka, learned counsel for the applicant. Also heard Mr. B. Chakravarti, learned Central Government Council as well as Miss S. Yasmin appearing on behalf of M. Sharma, respondent number 3. And Mr. S. Sancheti, you are appearing for?
For opposite party number 3, my lord. OP3. Respondent 2.
Ms. Sancheti appearing on behalf of respondent number 2 within bracket opposite party number 3 in IA number 2202/2025. Let this case be listed before any other bench without me within bracket my name on 16th of March. Whether I have shown it as part heard earlier.
Yes, your lords, because the matter was extensively argued, your
No,
lords.
in order sheet, whether it was mentioned as part, okay, then it is not necessary. Listed before any other bench on 16th of March.
Highly obliged.
Yes, lords.
G2 first hearing item. Yes.
Did you receive it?
Itu.
I can put.
May it please, Your Honor. My lord, we have filed one additional affidavit, my lord. Yeah. Also, may kindly have a look at para 2 and 3. my lord.
Additional affidavit, I say.
I see. I see. That's it.
Yes.
My lord, that is the factual position. Kindly have a look at para 2, my lord. That is our instruction. So on affidavit, we have filed it, my lord.
Yes.
And because they say, my lord, their signatures were taken, my lord. And my lord, on several occasions.
No, what is stated in para 2?
Prior to it is stated that, my lord, the investigating agency, my lord, once called the wife of the petitioner, my lord. They searched the house, thereafter not finding her, she was called. And there, my lord, her, my lord, signatures were taken, my lord. And on different occasions, when they, my lord, visited their house, my lord, signatures were taken, my lord, without showing any document, my lord. That is their contention, my lord. And our case is that, my lord, these facts, my lord, it may be disputed by them. It is also true, my lord. Only our case is that, my lord, if, my lord, that notice would have, my lord, in the hand of the wife, my lord, definitely he would have, my lord, complied with it. And we have stated also, my lord, in our para, my lord, 4, my lord, that part. And now, my lord, that day, my lord, that they stated, my lord, that notice was received by her. And, my lord, her acknowledgement was there. Now, lordship knows, my lord, that that until case, my lord, it followed the, my lord, there was a direction, observation that it has to follow that Aman Verma, my lord, that case, my lord. Amandeep Singh Johar, my lord.
What it says?
What it says, should I place it, my lord?
No, what you want to
My lord,
emphasize?
procedure, how 41A notice has to be served, my lord. There, my lord, and subsequently on the basis of those judgments, my lord, there is a, my lord, our High Court also, there is one, my lord. Not High Court, my lord, the government, my lord. That Home Department.
No, before you give
Yes,
the
my lord. So
judgment.
that could possibly be pertinent because, my lord.
What you want to emphasize?
I want to emphasize that, my lord, no notice was served upon them and the procedure, if they have, my lord, followed, my lord, investigating agency, possibly on perusal, lordship may go through the diary, whether it has been followed or not, only that part.
What is to be followed?
Because kindly see, my lord, that my lord, lordship may kindly see that third page, my lord. Procedure to be followed on issuance of notice and orders. That notification, my lord. Notification dated, my lord, 15 May 23, my lord. So there, my lord, this procedure is followed all over India, my lord. Now, my lord, lordship may kindly Down to that next page, my lord, here is no pagination, my lord, that 7A and 8, my lord, Roman 7A and 8. Because they have to, my lord, a duty index booklet has to be there, my lord. Serially numbered notices in triplicate carbon copy format should be issued by the OC so and so to the investigating officer. And it should contain, my lord, serial number, case number, date and time of appearance, and consequence in the event of failure to comply, and the acknowledgement slip. Thereafter, lordship, the next, my lord, the original is to be served on the accused suspect, my lord. In our case, we never got it, my lord. And my lord, the carbon copy on white paper is to be written by the IO in his or her case diary, which can be shown to the concerned magistrate as and when required. So this, my lord, whether it has been followed or not, my lord. Well, our case, my lord, we never got that notice, my lord.
But
We are-
your signatures are there.
Signature of the wife, my lord.
Yes,
Wife.
signatures of wife.
Wife. And whether, my lord, lordship may kindly see the diary, whether, my lord, the original never served upon us, my lord. Never, my lord. Otherwise, we would not have taken that ground also, my lord. That's why we took the instruction, my lord. They stated again that this, so we filed the additional affidavit. I am not on my contention, my lord. If the diary reveals, my lord, that the original or, my lord, this has been followed, my lord, possibly then my case is weak, my lord.
Yes, Mr.
Yes, what I have seen, lordship, I have seen one notice for appearance by police. And it has been all that things that they have to come and inquiry is going on, lordship, and her acknowledgement is also there, and her signature is also there, lordship.
No, is there any endorsement in the case diary?
It is there in the case.
No, let me put my question first, then answer. I have not yet put my question. Is there any endorsement in the case diary that the notice under 35(3) was served on the wife, original was served on the wife, a copy of which is kept in the case diary? Is any such endorsement merely keeping notice? Their contention is that you have obtained signatures of wife in the notice without serving the notice to her and kept the same in the case diary. You have to counter that.
Yes, lordship. I understand, lordship, what lordship has asked me the question, lordship. It is there in the ION note. It is there. They have served 35(3) notice, and they have not followed that, lordship. It is there, and it is also there. They have one.
Okay. Then
one
I'll
entry
go.
Also there, lordship.
I'll go through the.
But in original or not, my lord? That is the question put by your lordship, my lord. Because carbon copy has to be.
That I will go through.
My lordship may put that question to him, my lord, right now. He can say, my lord, whether it.
No,
Go through it.
I
not
will go through the case.
Not on that. My lord, but
I flag my lordship.
whether it is in original or, my lord, that he can submit, my lord, because carbon copy, no carbon copy to us, no original copy to us, my lord. Definitely, my lord, not given to us, my lord.
I'll flag it up.
Because if it is in, my lord, original, my lord, then possibly that our contention is true, my lord. Possibly, my lord.
Okay, heard Mr. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Shri Anil Chandra Nath, who is apprehending his arrest in connection with Morigaon PS case number 352/2024 under section 75 within bracket 2/78 within bracket 2 of BNSS. Whether investigation is complete or not.
Investigation is going on, lordship.
What is remaining?
Lordship, there are many persons are there, lordship. 9 victims are there, lordship. This person has harassed, lordship. The investigation is going on. Lordship, the entry part that, lordship.
Okay. No. Kalika, last word. Sons. Under section 75 within bracket 2/78 within bracket 2 of BNS, read with section 10/12 of the POCSO Act 2012. It is pertinent to mention herein that this is for the fourth time the petitioner has approached this court seeking anticipatory bail. Stop. His earlier three applications were rejected after perusal of the case diary. The gist of accusation in this case is Code Para 3 and 4 from page number 84. Learned Mr. A. Chaudhary, the learned counsel for the petitioner has submitted that the petitioner has approached this court seeking anticipatory bail on a new ground which were not considered by the court on earlier occasions. He submits that since the offense alleged against the petitioner entails punishment not of imprisonment not more than 7 years, it was incumbent on the investigating agency to serve notice under section 35 within bracket 3 of BNSS to the petitioner. In support of his submission, he has cited ruling of the apex court in the case of Satinder Kumar Antil versus Central Bureau of Investigation within bracket 2026 INSC 115. He further submits that as per the order dated 15th May 2023 issued by the Principal Secretary to the Government of Assam Home and Political Department in pursuant to the ruling of the apex court in the case of Amandeep Singh Johar versus Government of NCT Delhi. The procedure of serving notice under section 41A of the CRPC has been laid down. He submits that same procedure would be applicable in case of serving notice under section 35 within bracket 3 of BNSS also, as both are provisions in peri materia. Stop. He submits that as per the procedure laid down by the aforesaid judgment as well as notified by the aforesaid order, the original copy of the notice is to be served on the accused suspect and a carbon copy is to be retained by the IO, by the investigating officer, which can be shown to the concerned magistrate as and when required. He submits that in the instant case, though the prosecution side has claimed that the notice was served on the wife of the present petitioner, however, no such original or even a copy of notice under section 35(3) was ever served on the wife of the petitioner. He also submits that the petitioner is ready to cooperate in the investigation. He submits that as there is a violation of mandatory provisions of law, the petitioner is entitled to get protection under section 482 of BNSS in this case. On the other hand, learned additional public prosecutor, Mr. K.K. Das, has vehemently opposed the grant of anticipatory bail to the petitioner on the ground that on earlier 3 occasions, the court had rejected the prayer for grant of bail, anticipatory bail, considering the seriousness of the offense. He submits that the petitioner, being teacher or headmaster of a school, has subjected more than 9 girl students to sexual assault, and the investigation is still going on. He further submits that the notice under section 35(3) was served on the wife of the petitioner, and her signatures were also obtained on the said notice. He has produced
An entry is also made, Lordship. An entry to that
and,
effect is also made.
and an endorsement to that effect has also been made by the investigating officer in the case diary. He has produced the case diary of Morrigan PS case number 352/2024. Stop. I have considered the. Where is Amandeep's case? I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also considered I have also perused the case diary, which is.
My lord, lordships, if your lordship permits, can I add one line in?
Yes.
I'm sorry.
Yes.
Here, my lord, lordship, may kindly see that acknowledgement, because if she was called to the police station, that is also wrong, my lord. That cannot be done, my lord. The lady, my lord, cannot be summoned to the police station. It is there also in the Amandeep case.
No, whether you were called to the police station.
Yes, yes, we say we are called, because acknowledgement, that normal acknowledgement, my lord, there it is written that pursuant to the notice, so and so had appeared like that, my lord. That's why, my lord. If it was in the premise of the police station, that is also wrong, my lord.
Line.
I'm sorry, in between I've submitted.
Learned counsel for the petitioner also submits that the wife of the petitioner was called to the police station for obtaining her signatures on the notice under section purported notice under section 35(3), which is also prohibited by law. I'll go through the judgment and pass orders in chambers today itself.
Highly obliged.
You are appearing for? What's your name?
That Islam.
Also heard Mr. Zaid Islam, learned counsel for the informant. You are opposing?
As per my instruction, Lordship, client is not opposing as because they have come into an agreement long back.
What agreement?
Earlier lordship perused it, my lordship negated it, my lord. I am not on that that part, my lord.
Rest the limited Lordship.
Your lordship, earlier 3 orders, my lord, lordship has stated that although there was a no objection, but lordship was pleased to reject it. So that position remains, my lord. I am not on that, only this technical aspect.
Reflect Koribo. Zaid Islam, learned counsel for the informant, who submits that he has been instructed by his client not to oppose the grant of bail. Okay, I'll pass orders.
Highly
Hearing item 28.
You have to refresh the, it was heard in part yesterday.
Yes, sir.
Yesterday or day before yesterday.
Before yesterday.
You have completed your part.
Yes. Two vehicles were involved. I am the insurer of the I-10 car. The other vehicle was a tanker. This is the appointing vehicle as per deposition of eyewitness and contents of the charge sheet, exhibited charge sheet. But we are held 50% liable. So against that order.
But the Motor Accident Claims Tribunal has not discussed
Yes.
how you are liable.
Yes. Only as it is a case
Ultimately, it came to a fine.
that
It issued a direction against you also to
Yes.
pay 50.
the
Okay.
case of head-on collision, that is the learned tribunal's discussion. Is,
Yes.
in the case of head-on collision, so non-offending vehicle is also responsible.
Yes, Mr. Bhatto.
In this case, Lordship, no independent eyewitness was examined. Then Lordship, accident information report was issued against the Alto car, not against the truck.
AIR.
Yes.
Your submission is in the accident information report. Mention about the truck was not there.
Yes. Lordship. As per the preliminary inquiry that was issued against the
So what is your submission?
Lordship, there should be a proper finding in that regard, Lordship. When it is a case of head-on collision, and as per their report, would the front part of the wood vehicle damage? So unless and until there was an independent eyewitness to prove the case, all the police officer was also not examined before the tribunal to prove the charge sheet.
Who is the victim?
Victim is
Injured. You are the eyewitness also.
He was in the vehicle.
So you were claimant witness number 2.
Yes.
Your wife was examined as number
CW1.
CW1.
Exhibited all the documents because he is disabled now.
Is this the case where there was a statement of one of the PW that the truck came to the wrong side of the?
Only statement is that the rash and negligently coming from the opposite side.
Okay.
And that's the vehicle. Only that submission. In both the evidence as well as.
But no evidence against I-10.
No.
Okay. Yes, Mr.
This is why I want to cite page number.
On before judgment on facts, your submission is that AIR mentions only about I-10.
Yes, not against that.
Any other thing on fact side?
And let's say, MDA report which was exhibited, that also shows that the front part of the both vehicle were damaged.
When there is head-on collision, it will be there. Obvious. What it indicates.
There was specific evidence that the truck came from the wrong side and collided with the vehicle. There was no.
MVA report was exhibited as an exhibit.
I have checked my logs. In the lower court record, I have checked.
Exhibit 9.
Exhibit 9.
Exhibit 9.
Okay.
Okay. Yes. Wow.
And my humble suggestion, since it is a head-on collision and there is no positive evidence from the claimant side that truck was come from the wrong side and collided with the vehicle. So learned tribe would rightly
taken into consideration that it was a head-on collision and both the vehicle was equally responsible, driver or equally, it is a case of composite negligence.
Okay. Okay,
And
now,
I want to cite the judgment Lordship, Vijay Kumar Dugar versus Big Data Doctor. Lordship, I have already.
you have given the
Okay, I can give the number copy.
citation.
Vijay Kumar Dugar versus Big Data Doctor.
Yes, Vijay Kumar Duggar. Which para?
Page number, Lordship, page number 3, Lordship, will find in the middle part, Lordship. Adverting to the contention.
Which para? Para 1, 2, 3, page number 3.
2, 3, 4, 5, Lordship. Adverting to the
Averting to the next contention.
next contention of the claimants, no doubt the High Court has not dealt with the point in issue. However, we have noticed that the reasoning and the finding of the MSCT recorded under the issue number 2. It is the evidence of the Rajesh Kumar Gupta PW2 who was traveling in the Maruti along with the deceased Raj Kumar Dugar on the day of accident that he also suffered some injuries in the said accident. He stated that while coming from the Maruti car being driven by the deceased met with an accident at a place near Kharjan Pole. Before the accident, Raj Kumar Dugar noticed a passenger bus coming from the opposite direction and the movement of the bus was not normal as it was coming in a zigzag manner. The Maruti car being driven by the deceased Raj Kumar Dugar and the offending bus had a head-on collision. The MST has not accepted the evidence of PW2 to prove that the driver of the offending vehicle bus was driving the vehicle in an abnormal speed. If the bus was being driven by the driver abnormal in a zigzag manner, as PW2 wanted to believe the course, it was but necessary as the prudent man for the deceased to have taken due care and precaution to avoid head-on collision when he had already seen the bus from a long distance coming from the spot. The MST, in our view, has rightly observed that it had been done knocking one side of the car. The negligence or drivers of both vehicles should be held responsible and to have contributed equally to the accident. The finding on this issue is a finding of the fact, and we do not find any cogent and convincing reason to disagree with the well-reasoned order of the MSCT on this point. The MSCT has awarded interest. So in this case also, there was no allegation from the evidence of PW2 that the truck had come from the wrong side and collided with the car.
No, in this case, there was a contention that the bus was coming in a zigzag manner. The case which you have cited.
Yes, Lordship.
But in this case, there is no such evidence.
No such evidence.
The evidence is that it was driven in a rash and negligent manner.
Rash and negligent. But
the facts are distinguishable.
But the fact is that the accident took place due to head-on collision.
So is it your submission that in every head-on collision, there will be 50-50%?
When there is no positive evidence to that effect, that the one car is responsible for fully responsible for the accident. But in this case, there is no independent eyewitness. He was also not suspected witness.
Yes, anything else?
No.
Yes, Mr. Lekhan.
I, being the claimant, has nothing to say in the lease between the two insurance companies. Since the case is a composite negligence.
Oh, yes, this question was asked to
Yes,
you.
claimant has the option to file the claim petition any one of the wrongdoers or against both the wrongdoers.
When a case can be regarded as of composite negligence?
Yes, that will be clarified by this judge. Everything has been disturbed. What to do if Lordship has found that there is no negligence on the part of National Insurance? then they have to make the payment with a liberty to recover the same from the new entry.
No, no, we'll go to that later on.
Yes, boss.
Whether merely because of the fact that there was head-on collision between two vehicles,
Yes.
is it sufficient to come to the finding that there was composite negligence or anything else is required? If the evidence on records is only to the effect that it was, suppose there is head-on collision between truck and a Maruti car, and the only evidence on record indicates that it was the truck driver who was at fault. Charge sheet was laid against truck driver. The eyewitness pointed out towards truck driver. Then how the tribunal could come to conclusion that this is a case of composite negligence? Composite negligence means negligence by both the driver of the parties.
But third party.
You have understood my case
Yes.
and query. When court will come to the finding that a particular case is a case of composite negligence, is it sufficient that mere head-on collision is enough to come to the finding or anything else? This perhaps says that what is to be done when court comes to the finding that a case is of composite negligence.
Yes.
This is the judgment
Yes.
which lays down the law as to what is to be done.
Yes.
But before that, the tribunal must come to the conclusion that a case in hand is the case of composite negligence. That was my query on the last
Yes,
day.
yes, Lordship. Here, Lordship, only the tribunal, here appellants claim only the evidence of the CW2. CW2 in his deposition stated that he was sitting inside the car in the Honda.
CW2 is the eyewitness.
Eyewitness, he's the victim eyewitness. He stated that he was sitting in the car and the truck was coming rash and negligent manner and hit the I-10 car.
Yes.
Except that there is no other evidence that negligence, how much negligence of both the vehicle. There is no other evidence,
Yes.
either documentary or.
No, why to discard his evidence? He was cross-examined also.
Yes, that has to be replied by the New India Insurance because I being a claimant, I am entitled for the amount, either
No.
both of the parties.
No.
Yes, Lord.
You will be entitled from both parties only if it is a case of composite negligence. Suppose it is.
This case has been also reflect if the tribunal found that there is a proper evidence to come to a conclusion to decide the negligence of the vehicle, then the other party who is not negligence is entitled to recover the amount from the other vehicle.
Show me the.
Yes, Lord. This paragraph number 12 on our shoot. Paragraph number 12. What's your verdict?
Yes.
12. A full bench of Madhya Pradesh High Court in Srimati Susila so-and-so has also laid down that in case of composite negligence, the liability is joint and several, and it is open to impede the driver, owner, and the insurer, one of the vehicle to recover the whole amount from one of the joint officers. As to apportionment also, it has been observed that both the vehicle will be jointly and severally liable to pay the compensation. Once the negligence and compensation is determined, it is not permissible to apportionment the compensation between the two, as that it is difficult to determine the apportionment in the absence of the driver of both the vehicles appearing in the witness box. There is no other witness. One driver has died and the other driver has not been called for the witness box. Therefore, there cannot be apportionment of claim between the joint tortfeasors. The relevant portion of the decision of full bench is extracted herein under. When
No,
injury is
no,
caused,
Mr. Dekar, before you proceed.
Yes.
This judgment proceeds with a assumption that case is a case of composite negligence.
Yes.
There is no dispute.
Yes.
But in the instant case which we are dealing,
yes,
the tribunal has not held that this is a case of composite negligence.
yes,
Tribunal has, merely because of the fact that there is a head-on collision,
yes,
it just directed the appellant to pay 50%.
50%. So later part, what is composite, and that has been discussed also in the later part. When injury is caused as a result of a negligence of two joint tortfeasors, claimant is not required to lay his finger on the exact person regarding his proportion of liability. In the absence of any evidence enabling the court to distinguish the act of each joint tortfeasors, liability can be fastened on both the tortfeasors jointly, and in case only one of the joint tortfeasors is impleaded as party, then entire liability can be fastened upon one of the joint tortfeasors. If both the joint tortfeasors are before the court and there is sufficient evidence regarding the act of each tortfeasors, and it is possible for the court to apportionment the claim considering the exact nature of negligence by both the joint tortfeasors. It may be apportion the claim. It may apportion the claim. However, it is not necessary to apportion the claim when it is not possible to determine the ratio of negligence of joint tortfeasors. In such cases, joint tortfeasors will be jointly and severally liable to pay the compensation. On the same principle, in case of joint tortfeasor where the liability is joint and several, it is the choice of the claimant to claim damages from the owner and driver and the insurer of both the vehicle or any one of them. If claim is made against one of them, entire amount of compensation on account of injury or death can be imposed against the owner, driver, and insurer of that vehicle, as their liability is joint and several, and the claimant can recover the amount from any one of them. There cannot be apportionment of claim of each joint tortfeasor in absence of proper and cogent evidence on record, and it is not necessary to apportion the claim. To sum up, we hold as under: owner and driver and insurer of one of the vehicle can be sued, and it is not necessary to sue owner, driver, and insurer of both the vehicle. Claimant may implead the owner, driver, and insurer of both the vehicle or any one of them. There cannot be apportionment of the liability of joint tortfeasors in case of both the joint tortfeasors are impleaded as party, and if there is sufficient material on record, then the question of apportionment can be considered by the claims tribunal. However, on general principle of law, there is no necessity to apportion in the inter se liability of the joint tortfeasors. Reference is answered accordingly. Next, paragraph 20. In our opinion, the law laid down by the, that is not important, 14 is important. There is a difference between contributory and composite negligence. In case of contributory negligence, a person who has himself contributed to the extent cannot claim compensation for the injury sustained by him in the accident to the extent of his own negligence. Whereas in case of composite negligence, a person who has suffered has not contributed to the accident, but the outcome of the combination of negligence of two or more other persons. This court in T.U. and Anthony Soanso held that in case of contributory negligence, injured need not establish the extent of responsibility of each of the wrongdoers separately, nor it is necessary for the court to determine the extent of liability of each wrongdoer separately.
No, but it must come to a finding that
Yes,
to some extent he was, both are liable.
both are liable.
The percentage of
Contributed
contribution.
because there is no clear evidence.
Yes,
The driver.
but there must be some evidence to indicate that there was some negligence.
Here, in this case, in the accident information report, the offending vehicle was shown the item, Hyundai item. Second thing, the witness of the truck has not been called for. Whether only on that statement that the truck was rash and negligent manner, responsibility can be determined. That is the question, Lordship.
Okay.
Next paragraph, Lordship. It is only in the case of contributory negligence that the injured himself has contributed by his negligence in the accident. Extent of his negligence is required to be determined as damage recoverable by him in respect of the injuries have to be reduced in proportion to his contributory negligence. The relevant proportion extracted hereunder. The composite negligence refer to the negligence on the part of two or more persons where a person is injured as a result of negligence on the part of two or more wrongdoers. It is said that the person was injured on account of the composite negligence of those wrongdoers. In such cases, each wrongdoer is jointly and severally liable to the injured for payment of the entire damages, and the injured person has the choice of proceeding against all or any of them. In such cases, the injured need not establish the extent of responsibility of each wrongdoer separately, nor it is necessary for the court to determine the extent of liability of each wrongdoer separately. On the other hand, where a person suffers injury partly due to the negligence on the part of another person, and partly as a result of his own negligence, that the negligence of the part of the injured which contributed to the accident is referred to as his contributory negligence. Where the injured is guilty of some negligence, his claim for damages is not defeated merely by reason of the negligence on his part, but the damages recoverable by him in respect of the injury stands reduced in proportion to his contributory negligence. Therefore, when two vehicles were involved in an accident, and one of the driver claims compensation from the other driver alleging negligence, and the other driver denies negligence or claims that the injured claimant himself was negligent, then it becomes necessary to consider whether the injured claimant was negligent, and if so, whether he has solely or partly responsible for the accident and the extent of his responsibility. That is contributory negligence. Therefore, where the injured himself partly liable, the principle of composite negligence will not apply, nor can there be an automatic inference that the negligence was 50-50, as has been assumed in this case. The tribunal ought to have examined the extent of contributory negligence of the appellant and thereby avoid confusion between composite negligence and contributory negligence. The High Court has failed to correct the said error. Next, last part of that page, Lordship. The question also arises as to the remedies available to one of the joint officers from whom compensation has been recovered. That's it. Last part.
No, but to apply this principle, which
Yes.
you are going to read,
Yes.
the tribunal must come to a finding that both are joint tortfeasor, both
Yes.
drivers.
Yes.
Here, in this case, what is the evidence to indicate that the driver of I-10 was negligent in any manner? There is no evidence, except AIR mentions the I-10.
That is a documentary evidence, because offending vehicle was shown as the I-10. And the MBI report also, there is, my learned friend says, both the vehicle has been damaged.
And charge sheet has been laid against
The driver of the truck.
driver of the truck.
Because the driver of the I-10 has already expired. So therefore, question of filing charge sheet against him. He has also died.
No, what evidence is there to indicate the negligence of driver of the I-10? AIR one.
Air is there.
Apart from that, there is
not.
And there were other victim also in the car.
Yes.
As regards claim filed by
That cannot claim, because that in one of the victim has filed a claim petition against the New India, and that is not judgment has not been delivered. That is settled at the initial stage.
Okay.
So therefore, that cannot be taken help in this case.
Okay.
Because in this case, the national insurance has not adduced any evidence.
So what is your submission that as as regards the claimant,
Yes,
both were joint tortfeasors,
yes.
and therefore you were at liberty to file case against any one of them.
Then we have filed against both of them that they are liable. If they succeed to prove that they are not liable to the pay, then they can recover from the New India. Last part says that, Lordship. The last part of the judgment. The question also arises as to the remedies available to one of the joint tortfeasors from whom compensation has been recovered. When other joint tortfeasor has not been implemented, obviously question of negligence of non-implemented driver could not be decided. Apportionment of composite negligence cannot be made in absence of the implement of the joint tortfeasors. Thus, it would be open to the implemented joint tortfeasors
No,
after
in this case, both were implemented.
in this that is coming.
Yes.
Thus, it would be open to the implemented joint tortfeasor after making payment of the compensation so as to sue the other joint tortfeasor and to recover him from the contribution to the extent of his negligence. However, in case when both the tortfeasors are before the court tribunal, if evidence is sufficient, it may determine the extent of their negligence so that one of the joint tortfeasor can recover the amount so determined from the other joint tortfeasor in execution proceeding. Whereas the claimant has the right to recover the compensation from both or any of them. This is my case, Lordship. And the last finding of this judgment, Lordship, at last page, Lordship, what emerges from the aforesaid discussion is followed. Last page.
Yes.
In the case of composite negligence, plaintiff claimant is entitled to sue both or any one of the joint tortfeasors and to recover the entire compensation as liability of joint tortfeasor is joint and several. In case of the composite negligence, apportionment of compensation between two tortfeasors vis-a-vis the plaintiff claimant is not permissible. He can recover at his option whole damages from any one of them. In case of all the joint tortfeasors have been implemented and evidence is sufficient, it is open to the court tribunal to determine inter se extent of composite negligence of the driver. However, determination of extent of negligence between the joint tortfeasor is only for the purpose of their inter se liability, so that one may recover the sum from the other after making.
In the instant case, how
Yes.
it was decided 50-50?
Because both are equally liable, equally divided. 50-50
No,
has
no.
been given.
How the court came to the finding that both were equally liable? On what evidence?
Only just accident information report.
And there was head-on collision.
Head-on collision. There is no independent eyewitness except the claimant number two, claimant himself. There is they have not called for the driver of the owner truck also. They have not adduced not a single evidence. So whether from that statement of the claimant number two, it can be said that the negligence has been proved.
Otherwise, you are claimant.
I am claimant, I am safe, I am entitled from.
No, not so safe. Before the tribunal,
Yes.
you took the plea that driver of the truck was negligent.
Not so negligent, only statement coming rash and negligent manner, hit the item. Only that much. Apart from there is nothing in evidence.
Okay, okay. Then what is your?
So my submission, if Lordship held that the tribunal is wrong in holding the liability to the national insurance, then they maybe make good the payment to us with a liberty to recover from the New India. That is my submission, Lordship.
Yes, that is one option.
That is because this judgment laid this. They cannot escape from the liability. They have to pay with a liberty to recover from the other insurance. That is the last finding of this judgment said.
Lordship, I'm reading this line.
Cost of the claimant. Suddenly one oil tanker, this is the statement only, oil tanker bearing so and so coming from opposite direction in a very rash and negligent manner, knocked down the I-10 car. As a result, I sustained severe injury on my head, spinal and fracture so and so, so and so. He has not stated that he is solely only said the rash and negligent. He has not stated that solely for the negligence of the truck, the accident has been occurred. So that statement is required. There is nothing logical.
Lordship, kindly see the para number 12 of the judgment, Lordship, lower court judgment. The evidence of the claim.
Para number
Para number 12.
12.
12. Page number 12, Lordship. In the memo appeal.
Yes. Yes.
The evidence of the claimants and the copy of the accident information report, FIR, seizure list, and search sheet prove the fact that the accident was caused due to rash and negligent driving by the drivers of vehicle bearing registration number tanker and AS23Z 0600 I-10 car. That apart, the record reveals the oil tanker bearing mentioned registration also being driven by its driver from the opposite direction in a very rash and negligent manner. That's the I-10 car. There was head-on collision between the vehicle and search sheet was filed against the driver of the offending oil tanker. So from the discussion on record, it appears that the accident was caused due to rash and negligent driving on the part of the drivers of both the offending vehicle bearing registration so and so. Lordship, first of all, Lordship, accident information report was issued against the car, not against the truck, Lordship. So the accident information report was issued against the driver of the Alto car, which indicate that the investigation agency also found the fault on the part of the Alto driver. Item driver. But that is why learned member on the basis of this all document came to conclusion that it was a head-on collision and both the driver of the vehicle contributed equally for happening the accident. And there was no independent eyewitness before the tribunal. Not the investigator or the search sheet was also examined before the court.
Yes, Miss. You have any reply?
Yes, Lordship. The case is filed under section 166 of the AVA Lordship. As per 166 Lordship, rash and negligent driving is required to be proved. In this case, whatever evidence is there says that rash and negligent driving only of the tanker, oil tanker. There is no evidence that the I-10 car is anywhere responsible in this accident, Lordship. And rash and negligent driving is proved by the filing of search sheet and evidence of the eyewitness claimant, Lordship. And in my submission, he is independent witness in the sense that he is nowhere liable to get any amount deducted. There is no question of contributing negligence, but because he was sitting a passenger, the principle of contributing negligence does not come in this case, Lordship. He is entitled to get awarded amount. He has not contributed to the accident. He was only a sitting passenger, Lordship. He could have claimed compensation from either of the vehicle if it were responsible, whichever is responsible. But his evidence is clear that accident took place due to fault of the oil tanker, not of the I-10 car, Lordship.
Okay.
So the question of contributing negligence does not come in this case. And the composite negligence, Lordship, it must be proved. There is no oral evidence or no documentary evidence to prove that our I-10 vehicle is responsible for the accident, Lordship. And the police, after making thorough investigation, filed the search sheet against the oil tanker, Lordship. The AR, that means, Lordship, initial finding was found something else that is not relevant in this case, because after
proper investigation, after thorough investigation, if anything is found, is against the oil tanker, Lordship. So oil tanker is rightly held liable in this case. As per Lordship, MVI report, Lordship, in case of any head-on collision, head side portion will be damaged of both the vehicles, Lordship. If I am in the proper side of the road, then also my vehicle can get damaged, Lordship. So head-on collision and MVI report does not prove that the non-offending vehicle is also responsible for the same loss. And the judgment that my learned friend has related, Kenny's judgment, I think, Lordship, that judgment is not relevant in this case, Lordship, in the sense that in that case, composite and joint tortfeasor what are discussed, Lordship. In this case, there is no material to prove that we are responsible, and joint tortfeasor question does not arise in this case, Lordship. In that case, there is question of joint tortfeasor, but in this case, evidence on records show that this vehicle is not a tortfeasor, Lordship. The owner is not responsible, the driver is not responsible, and so insurance company is not liable to indemnify the owner.
Okay. Heard. Mr. A.J. Soikia, learned counsel, the learned counsel for the appellant. Also heard Mr. K.K. Bhatto, the learned. No, also heard Mr. S. Deka, the learned counsel for respondent number 1, claimant, as well as Mr. K.K. Bhatta, the learned counsel for respondent number 3, New India Insurance. New India Insurance. This appeal under section yes, New India Insurance. New India Insurance Company Limited. Stop. Next paragraph. This appeal under section 173 of Motor Vehicles Act has been filed by the National Insurance Company Limited, impugning the judgment and award dated 29/5/2018 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, Gauhati in MSC case number 306/2012, whereby the respondent number 1, claimant, was awarded a compensation amount of rupees 29,82,959 959 It is a death case. Then why file?
Lordship.
Why the claimant is why? US Deepshikha Roy is the wife.
He's been bedridden, claiming
Okay.
because he's 50% disabled.
Okay. Last line.
The respondent number 1 of the claimant was awarded a compensation amount of rupees
59. The tribunal, the Motor Accident Claims Tribunal, by the impugned judgment, directed the respondent number 3 as well as the present appellant to share the liability of paying compensation to the extent of 50% each. Stop. The facts relevant for consideration of the instant appeal, in brief, are that on 1/2/2012 at about at about 11:15 p.m. the husband of the present appellant, husband of the respondent number 1, namely Jayanto Kumar Kaur, was traveling by a Hyundai i10 car bearing registration number AS23Z0600 from Lidu Sahitya Sabha towards his residence situated at Tinsukia. Stop. On his way, when he reached Kharjan Pole at National Highway number 38 under Digboy Police Station, a oil tanker bearing registration number AS23B9981, being driven in a rash and negligent manner, dashed the Hyundai car in which the husband of the present appellant was traveling from the front side, as a result of which the husband of the present appellant sustained grievous injuries on his person. Stop. Thereafter, the injured Jayanta Kumar Kaur, represented by the present appellant, approached the Motor Accident Claims Tribunal number 2, Kamrup Metro, by filing an application under Section 166 of the MV Act, 1988, seeking compensation on account of injuries sustained by him in the aforementioned motor vehicular accident. The said case was registered as MAC case number 306/2012. Stop. The present appellant as well as respondent number 3 contested the claim of the claimant by filing written statements. Wherein they denied their liability to indemnify the owner of the vehicles involved in the accident. Stop. Upon pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Quote from A at page 10. Ultimately, following issues. Stop. During the inquiry, next para, during the inquiry, the respondent number one, present respondent number one, within bracket claimant, had adduced evidence of 4 witnesses and exhibited certain documents. Both the insurance company, that is the present appellant, as well as respondent number 3, did not adduce any evidence during the inquiry before the Motor Accident Claims Tribunal. Ultimately, by the judgment and award which has been impugned in this appeal, both the issues were decided in favor of the claimant, and the tribunal came to the finding that the accident in question was caused due to rash and negligent driving of the drivers of both the vehicle involved in the accident, namely the tanker bearing registration number AS23B9981, as well as the I-10 car bearing registration number AS23G0600, and directed both the insurance company to share the liability to pay the compensation amount to the claimant to the extent of 50%. Stop. The aforesaid judgment and award has been impugned by the present appellant mainly on the ground that though there was no evidence on record indicating any negligence on the part of the driver of the I-10 vehicle, however, the present appellant was also directed to pay 50% of the awarded amount to the claimant. Stop. Learned Mr. A.J. Saikya, the learned counsel for the appellant, submits that the Motor Accident Claims Tribunal had erred in holding that the driver of the present vehicle, driver of the I-10 vehicle, was also liable and negligent without there being any evidence on record to that effect. Stop. He submits that merely because he submits that the tribunal has, the Motor Accident Claims Tribunal has erred in coming to the aforesaid finding merely on the ground that in the accident information report, the mention of I-10 vehicle is there, while it did not consider the fact that after investigation on the basis of FIR which was lodged after the accident, charge sheet was laid against the driver of the offending oil tanker. He further submits that the tribunal also failed to take into consideration the fact that the sole eyewitness whose evidence was, who was examined during the inquiry, that is the claimant himself, has categorically stated that it was the offending oil tanker, which was driven in a rash and negligent manner, and it hit the I-10 from front side. He submits that there is no direct evidence apart from the mention of the I-10 car in the accident information report to indicate that there was any negligence on the part of the driver of the I-10, and therefore he submits that this is not a case of an accident resulting due to composite negligence of driver of the two vehicles. He submits that in an application, in an inquiry which has been initiated upon filing of an application under section 166 of the MV Act, unless the evidence is there on record to indicate any fault on the part of the driver of the I-10 car, there it does not fall within the category of a case of composite negligence. He submits that as the only evidence on record was against the driver of the oil tanker, the Motor Accident Claims Tribunal had erred in directing the present appellant to share the 50% of the liability to pay compensation to the claimant. Anything else from any other submission from you? You have cited two rulings yesterday.
One.
Yeah, which one?
Lordship, that is regarding charge sheet, Lordship. The value of charge sheet.
Which case?
Lordship, New India versus Pachanmal, it is Kerala High Court.
Okay, which paragraph?
Paragraph, Lordship, 6, 7, 8. And one thing also I want to further submit. Also, the other side has submitted that charge sheet does not say that due to death of our insured vehicle's driver, the charge sheet was filed against the oil tanker driver. There is no finding in the charge sheet in such line.
Okay.
And we have taken also plea Lordship 304. Another case was settled by the New India taking full liability loss. That is in
Yes.
evidence on record also.
Stop. Learned counsel for the appellant has further submitted that the Motor Accident Claims Tribunal also erred in not taking into consideration the fact that the charge sheet was laid in the case which was filed after the aforesaid accident, only against the driver of the oil tanker under section.
Lordship, 279, 338, 304A, 427 IPC.
Under section 238,
279, Lord.
279,
338,
338,
304A,
304A,
427.
427 of IPC. He submits that apart from the aforesaid charge sheet, the oral testimony of CW2 also indicated towards the fault of the driver of the oil tanker only, and there is no reliable evidence against the driver of the I-10 vehicle. Hence, he submits that the trial court was wrong, in absence of any acceptable evidence to attribute negligence to the driver of the I-10 vehicle. He further submits that in a connected claim case filed by the one of the who has filed that?
Lordship, wife of
Filed by one of the
who was occupant of the I-10 car. That is number is
filed by wife of one of the occupant of the I-10 car who ultimately died in the accident. Within bracket MAC case number
304/12.
304/12, the respondent number 3 herein, that is the insurance company of the offending oil tanker, has settled the matter amicably with the said claimant, accepting the entire liability to pay the compensation to the said claimant. He therefore submits that in absence of any evidence of negligence on the part of the driver of the offending vehicle, driver of the I-10 vehicle, the tribunal has wrongly directed the present appellant to pay 50% of the awarded amount to the claimant, and as such he submits that the aforesaid that the impugned judgment and award is liable to be set aside to the extent it has directed the present appellant to pay 50% of the awarded amount. Stop. On the other hand, Mr. K.K. Bhatto, the learned counsel for the respondent number 3, has submitted that there is no infirmity or illegality in the impugned judgment and award passed by the Motor Accident Claims Tribunal. He submits that the Motor Accident Claims Tribunal has correctly arrived at the finding, on the basis of materials available on record, that the accident in question was caused due to negligent driving of drivers of the both vehicles, namely oil tanker as well as the I-10 car. He submits that the accident information report, which was produced during the inquiry before the tribunal, before the Motor Accident Claims Tribunal, clearly mentions only the I-10 car as offending vehicle, and it does not mention anything about the oil tanker. He further submits that the MVI report, which was exhibited as Exhibit 9, also clearly indicates that the front sight of both the vehicles were damaged, to indicate that there was a head-on collision between the vehicles, and which itself indicate that there was negligence on the part of the driver of the I-10 vehicle also. He also submits that the present appellant also did not adduce any evidence during inquiry to show that the driver of the I-10 vehicle was not at fault. So he submits that as there was clear indication from the materials on record that the accident was caused due to head-on collision between oil tanker and the I-10 car. The tribunal was correct in attributing the negligence which caused the accident to drivers of both the vehicles. And in absence of any evidence exonerating the driver of the I-10 car, the tribunal could not have reached a contrary finding. In support of his submission, he has cited a ruling of the Apex Court in the case of Bijoy Kumar Duggar versus Vidyadhar Datta and others, reported in 2006 3 SCC 242. Mr. Bhatto, any other thing? Any other submission which I have not, that I have mentioned? As such, learned counsel for the respondent number 3 has submitted that the present appeal is liable to be dismissed. Stop. Mr. S. Deka, the learned counsel for respondent number 1, claimant, has submitted that the since two vehicles are involved in the accident, and since there was a head-on collision between both the vehicles, as well as there is no independent witness examined by the insurance company to which could have exonerated the driver of the I-10 car from negligence which resulted in the aforesaid accident. The tribunal was correct in coming to the finding that this was a case of composite negligence of the driver of the I-10 vehicle as well as oil tanker. He submits that he also submits that since the accident information report only indicates about I-10 car as offending vehicle, this cannot be a case where there is no evidence, at least at the initial stage of the investigation, that there was no negligence on the part of the driver of the I-10 vehicle. He submits that in a case of composite negligence, both the joint tortfeasors are jointly and severally liable to pay compensation to the claimant. He also submits that the plea that one of the claimant in another claim case arising out of said accident had arrived at a amicable settlement with respondent number 3 will not in itself exonerate the driver of the I-10 car from the negligence in which caused the accident, as there was no judicial determination in that claim case, and it was settled only on the basis of amicable settlement between the parties. He submits that what else is your submission?
If this court held that the national insurance has no fault, then also they can
yes,
say
yes.
the amount to recover the.
He also submits that if it is ultimately found by this court that the driver of the I-10 vehicle was not at fault which caused the accident, still it may direct the insurance company of the I-10 vehicle to pay the compensation to the extent of 50%, as was directed by the Motor Accident Claims Tribunal, and thereafter they may recover the same from respondent number 3. In support of his submissions, learned counsel for the respondent number 1 has cited a ruling of the apex court in the case of KHENYEI versus New India Insurance Company Limited, reported in 2015 9 SCC 273. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. Stop. I have also perused the rulings cited by learned counsel for both sides. I'm reserving the judgment. Hearing concluded, judgment reserved.
Also, one thing I submit, statutory deposit along with interest may be returned to the appellant. So, one citation and yes. With interest.
Along with interest.
Yes, no, there are some judgment also. I am sketching one.
Who will compute the interest?
Also, registry completes also.
How? At what rate?
Also, registry sends the details to the bank. Bank calculates and returns. We have received some cases in some cases. Also, may write with interest, if any. Also, that word also may be added. If any.
Okay.
Obliged.
May it please your lordship. Lordship heard this case.
In part.
Yes. And then.
I don't remember
Yes,
anything. You have
I'll
to
come to
refresh.
that. And then lordship, after hearing lordship said that, I mean, since the owner is not here, so I should also argue why he should not be made liable. Because basically what we are saying that we will be paying to the claimants, but we need a recovery order from the owner, lordship. Why, lordship?
No, last order is a long order.
Yes, it was ex parte against the owner. Lordship can.
I have heard only you or.
No, him also, lordship.
I'm for the claimant.
Claimant also. Owner, if in spite of notice, he did not appear. Then some counsel was also appointed. They also did not appear. So last order lordship passed ex parte and asked me to defend the owner in his absence, something like that. That is what I understood.
Okay, let us hear.
Yes, Lordship,
There are only one MEC case.
only one.
Yes.
Lordship, the grounds of appeal, or should I start with the judgment, Lordship?
You just tell me the gist.
Gist, Lordship, is that there was this person uh, uh, for death of her husband, Chandraprabha Das, who is the claimant, Lordship. She filed the case and she claimed 50 lakhs of rupees. And the accident had taken place on 8/3/2013 at 1:35 a.m. Then, Lordship, after hearing the evidence was adduced by the claimant, she exhibited the accident information report, certified copy of FIR, certified copy of charge sheet as Exhibit 3, certified copy of postmortem report examination, higher charge of Tata Sumo as Exhibit 5. So, Lordship, basically on charge sheet and higher charge of, we are not denying that the accident had taken place. We are not denying that she will not be entitled to the compensation, Lordship. We are not denying that. We are only on the fact that as per the charge sheet and as per the higher charge of Tata Sumo, Lordship, Exhibit 5, the vehicle was taken on hire as it is mentioned in the charge sheet. So we adduced evidence and we said that there was violation of policy condition because the vehicle was a private vehicle and it was given on hire. That is our appeal, Lordship.
Okay, so there was violation of a policy condition, therefore you are not liable to indemnify. That is your case.
That is my case. The learned tribunal, Lordship, did not accept it because it mentioned that we did not file any written, we did not mention it in our written statement. But, Lordship, at para 12 of our written statement, we have mentioned it. That any violation to the policy condition, the insurance company will not be liable. Lordship, I have also annexed that document, that is page 15, Lordship. So when Lordship, when the vehicle was taken on hire, there is no question of the insurance company paying the compensation. Of course, we can at the first instance, we have to give the compensation to the claimant and then we get a right to recover from the owner. That is our limited ground. I'll submit something if we add something, then I can.
Oh, what is the evidence that it was taken on hire?
Evidence, Lordship? We adduced evidence of DW, Lordship, the evidence.
The tribunal held that you failed to establish.
No, not failed to establish. We did not plead. Paragraph 19. In view of above discussion, it is concluded that the plea of the insurance company that the offending vehicle was used in commercial purpose is beyond pleading. And the same has not been established. So it is held that the OP.
So two things. Tribunal said that it was not pleaded, neither it was proved.
Proof, Lordship, claimant themselves proved the charge sheet where it is mentioned. I have also translated the copy of the charge sheet, Lordship. It was mentioned that it was taken on hire and Exhibit 5 is the higher amount, the higher charge of Tata Sumo as Exhibit 5. It was there on the document. And because of this document, we adduced evidence, Lordship. As per their.
What is Exhibit 5?
Exhibit 5 is higher charge of Tata Sumo. That is mentioned at page 8 of internal place 3, but page 8 of my memo of appeal, Lordship, paragraph 8, last part. She exhibited the accident information report at Exhibit 1, certified copy of FIR as Exhibit 2, certified copy of charge sheet as Exhibit 3, certified copy of postmortem report as Exhibit 4, higher charge of Tata Sumo as Exhibit 5. Paragraph 8, Lordship, got it? Page 8 and paragraph 8.
What is higher charge?
Lordship, which in Ohomia we say ki poisa dilu garikhon bhara koribo karone.
But is it a document?
There is a receipt, Lordship. That's what we exhibited. I think. Asan the commercial files from the
Putul. Trial. Trial.
Lordship, regarding exhibit 5, the learned tribunal discuss in para number 20, page number 11. Para number 20, the last portion, if your lordship have.
What it says?
The claim, para number 20, lordship, the claimant has submitted that her husband was working as a lender operator.
Husband or higher charge?
Yes.
No, this is a certificate, exhibit 5.
Yes. no.
Certified that so and so.
Stand
Referred-
corrected, Lordship. Then I stand corrected, Lordship. What he's saying is that it was her husband's income, I think. Income
Yes.
they cover.
My learned friend referred to exhibit 5, that's why I pointed out. Para
Which is higher
20,
on.
it is income, regarding income.
No, no. What is exhibit 5?
Beside it, in that certificate, exhibit 5, the name of the owner has not mentioned, so it is not safe to accept that the husband of the claimant was not the owner of the vehicle mentioned in exhibit 5. In Lordship will find in para number 20 of
Okay, I'll come to you later on. No, why are you relying on exhibit 5?
No, Lordship, I was mistaken because here I did not have that exhibit, Lordship, with me. Now I stand corrected, Lordship, because he's saying that it was given to prove the income of the deceased. I thought that the higher charge was, but the Lordship charge sheet, I have this translated copy, Lordship. I have translated it.
Charge sheet was exhibited.
It was exhibited as exhibit 3, Lordship.
What is there in charge sheet?
Lordship, description of case is that on demand, the claimant, Srimati Chandraprabha Das, wife of late Upen Chandra Das, resident of Utla, Komargaon PS, something I couldn't get it, district Dorong, Assam, by submitting a written ejahar in the Thana, informed that on 7/3/2013 at night around 9 p.m. the driver of the Maruti van bearing number so and so, Sri Monju Bora, son of late Banshidhar Bora, was heading towards Thikiajuli, whose vehicle was taken on hire by the complainant's husband. This is the part we are we are relying on to agitate in our appeal, Lordship. That the vehicle was taken on hire, whereas it was a private vehicle, Lordship.
Okay.
And that is why we have filed the appeal, Lordship, because when we mentioned it in our written statement, as well as it was the own document of the claimant, Lordship, and as per her own FIR, Lordship, this charge sheet was given. So, Lordship, in that view of the matter, there was clear violation of policy condition. The court was wrong into coming to the conclusion that it remained not proved and not established. Has not been established. Purpose is beyond pleading and same has not been established. Pleading is there, paragraph 12, and established their own document, Lordship. We just adduced evidence by proving the policy and this document.
Okay, anything else?
Basically, Lordship, on quantum, I'm not on quantum, Lordship.
Basically on the liability itself.
Yes, not on
Then
quantum
there was, yes,
violation. So, Lordship, they have also not filed any appeal to increase the compensation. So 19,58,000 plus 6% interest was given. So that will, I think, stand.
yes,
We
Mr.
submit-
Bhattakur.
Lordship, so far as the submission of my learned friend, what I understand that they are not disputing the entire judgment regarding the quantum and other part. Only thing is that who will pay, and if pay, how to recover, pay and recover. If there is a breach of policy condition, then they may be allowed to recover from the owner of the vehicle. This is their case. I am the claimant, not I have otherwise no objection for them because
No,
I am entitled-
you may have some objection.
my
Suppose it is payable by insurance company.
Yes.
Then you will get it sooner.
No, otherwise also he will get it sooner, Lordship, because we will be paying them and then recovering.
Recovering.
Yes.
Okay.
So,
What happened actually?
in fact, pendency of
earlier-
the appeal has
Yes, earlier that lordship what happened, when the lordship heard the matter at length for the first time, thereafter to keep it as part heard. On that day, my learned friend relied upon a judgment of Honorable Apex Court, Nanjapan. In that judgment, there was some condition where it is mentioned that you first file an application before the trial court, call the owner of the vehicle, take some bond and surety, thereafter you release the amount to the claimant. That was the verdict of the Nanjapan. But I am relying upon a judgment of Manwara Khatun reported in 2017, Lordship, Supreme Court judgment, where it is clearly mentioned, it is 2 or 3 MSc appeal was from
Taken
our
together.
Gauhati High Court.
Court judgment.
to the
Manwara
Supreme-
from our high.
Yes, from our High Court also. It is the Supreme Court, para number 14.
Yes. Yes.
Para number 14, for a moment, Lordship. The only question which arises for consideration in these appeals is whether the appellants are entitled for an order against the insurer of the offending vehicle, that is the respondent number 3, to pay the awarded sum to the respondent and then to recover the said amount from the insurer, owner of the offending vehicle, that is Tata Sumo, respondent number 1 in the same place. The aforesaid question, in our opinion, remains no more res integra, as we notice it was subject matter on several decisions of this court renders in 3 judges bench and 2 judge bench in past so and so. This question also fell for consideration recently in manager so and so Supra, wherein this court took note the entire previous case law on the subject mentioned above and examined the question in the context of section 147 of the Act. While allowing the appeal filed by the insurer, the company, by reversing the judgment of the High Court, it was held that on the fact that since the victim was traveling on the offending vehicle as just passengers, and hence the insurance company cannot be held liable to suffer the liability arise out of the accident on the strength of the insurance policy. However, this court, keeping in view the benevolent object of the Act and on relevant factor arising in the case, issue direction against the insurance company to pay the awarded amount to the claimant and then to recover the said sum from the insurance in the same proceeding by applying the principle of pay and recover. And finally, Lordship, para number 23 also, finally the court allowed the appeal and directed the insurance company to pay the amount to the claimant first and thereafter to proceed in accordance with law to recover the amount from the owner of the vehicle. Second judgment, Lordship, of our High Court.
No, how it differs from Nanjapa's judgment?
In that
Lordship,
case,
I have
Lordship, with the second page of my judgment, Lordship, this judgment, it is referred by the Honorable Supreme Court, but it's not relied. Nanjapan is referred there. Lordship will find the second judgment. Second judgment, Nanjapan is there, referred by one party.
Which judgment?
Yes, this one. What I presently reading, Lordship, Manwara Khatun. Page number, second page, Lordship, case referred. The second case is Nanjapan case. It is referred before the Honorable Apex Court, but it is not relied by the court.
It was not discussed.
Yes. It is referred by some either party, but it is not. It is also mentioned in the judgment, but it is not relied by the Honorable Supreme Court. And secondly, my lord, of our Honorable Gauhati High Court.
Nanjapan's case is a judgment by division bench.
Lordship.
In Nanjapan's case,
Yes.
how many judges were there?
Nanjappan Lordship 2.
This is
Right,
also-
Swami Raju. Raju and Arijit Pasaya.
No, what is the difference between this judgment which you are referring and Nanjappan judgment?
Nanjapan judgment is that, in Nanjapan judgment, Honorable Apex Court directed the insurance company to proceed against the owner of the vehicle before payment to the claimant, file an application before the tribunal.
So it will
Issue
keep on
notice.
halt
Yes,
the payment portion.
yes, exactly. No,
No,
I have to take some security, and if necessary, or the offending vehicle may be seized. And take some security or bond from the owner, thereafter release the amount. That was a condition in that particular judgment. But in Manwara Khatun, it is not like that. The Honorable Apex Court says that you pay first and thereafter proceed in accordance with law. And second judgment, for a moment, if your lordship peruse of our Honorable Gauhati High Court, Oriental Insurance Company Limited, Jatindra Nath Deka, where my learned friend is the counsel on record. In that case, company is also same, my lord. Para number 9. The appellant submitted that the owner cum driver of the vehicle had violated the policy condition and therefore he should have been held liable for paying the compensation. It has been submitted that the driving license number so and so was not issued in the name of the driver. The tribunal held that since the vehicle was insured by the appellant, therefore the insurance company appellant cannot escape its liability to pay compensation. The appellant insurance company has examined one witness to prove that there was a violation of policy condition as because the owner and driver of is not did not have a valid license. Exhibit B is the document which disclosed that the respondent number 2 is the owner cum driver did not have license. Rather, the license relied upon by the respondent number 1 claimant was issued to one Chachinder Sharma. Thus, the breach of policy condition has been established by the appellant insurance company. In spite of the aforesaid fact, since there was a valid insurance policy, the insurance company cannot escape from its liability to pay the compensation. However, in that case, the insurance company shall be entitled to recover the compensation from the owner. Last paragraph, under the said premises reason, the appeal is partly allowed. The impugned judgment is modified to the extent that the insurance company shall pay the compensation and thereafter, insurance company shall have the liability to recover the money from the owner of the vehicle. This is judgment of our High Court.
So here the ratio is that if there is a valid insurance policy,
no, we are also not denying that
they are
in
not
the
denying on
present case also the policy was not there. No, we are not saying that. Nanjappan Lordship, Nanjappan Para 8, it mentions how it is to be. I had given last time.
Yes, yes.
It your যদি না record and I'm also relying on this Shamanna judgment lordship, wherein that Nanjappan economy.
now what is the basis for pay and recovery? Why pay and recovery is
That's
allowed?
from Swan.
No, what is the basis? Basis in the Manwara's case is the
Rescuers passenger.
benevolent object is the basis because the
Basis.
why it is directed. If benevolent object is the basis, then
So that the claimants do not suffer lordship.
then Nanjappa's case delays the disbursal of the.
That is just by a month or so, lordship, because what Nanjappan says is that we will deposit the amount and then the notice to the owner will be sent. And
But we have seen in serving the notice, it takes lot of time.
no, lordship can fix a time frame. Otherwise, also lordship can fix
But
a time.
Manwara does not specify anything like that.
Manwara does not specify. That is true, lordship.
And both are
But recovery is there. And in Shamanna also lordship, the apex court has held that Shamanna have given lordship, that same pay and recovery will be there.
in this case, you are not agitating the if it is directed that you pay and then recover from.
No, that's why I gave Nanjappan case lordship that yeah, but ultimately it is because lordship, in many cases, like my friend has shown, I was there in that appeal. My appeal was allowed, in fact, but pay and recovery was. So in many cases, I can show Rajkumari, Justice Budhi Habung passed that judgment. In that, we were given as per Nanjapan. So in many cases, judgments are given as per Nanjapan. Many cases, just like Manwara or this.
Another
So
judgment,
it is
same co-pedi by Lalit Pedis appeared of our High Court, where like Nanjapam, another judgment is there. Chella Bharatamma, Chella Bharatamma also put some condition, but this honorable court observed that may be facts to facts. In some cases
Yes,
may be
that's what
applied, but
I'm
in
submitting.
not all the cases. In para number 18, this is very much clear, my lord. I have the judgment.
So
For a moment,
both ways judgments are there, lordship. So it will be ultimately
It cannot be applied for in all cases.
lordship's discretion, lordship, how
The
lordship.
para number 18, my lord. Para number 18 is important of our High Court. For a moment, if your lordship perused.
We will continue after lunch.
Yes, my lord.
What is the stand of the owner of the?
No, ex parte.
Owner,
Oh, it is proceeding ex parte.
yes,
Yes, last time that long order was because of that.
We'll continue after.
Fine.
With your lordship,
Yes.
the consent of the other side, I am mentioning item number 12 and 13 lordship.
12 and 13.
Lordship.
What is your prayer?
Chief engaged counsel is out of station as his father has been admitted to the hospital. Lordship.
Heard Miss
H. Borwa.
H. Borwa, learned counsel for appellant or respondent, learned counsel for the appellant who seeks an adjournment due to personal difficulty of the conducting counsel for the appellant. She further submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who has no objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed on 12th of May.
Bless.
Yes.
As per the last submission on my part, lordship, it is not a disputed fact that the insurance company is also not inclined to pay the compensation amount to the claimant. They are inclined. We are also on that. I am the claimant. My learned friend is also for pro forma dependent. He is also part of the claimant relative. The lordship, if that is so, I mean, there is a certain position of law that pay and recover, then the lordship may direct the insurance company to pay the
No,
deposit
no.
amount to the tribunal.
Before that,
Yes.
from your side, what is your submission regarding their contention that there is a violation of policy condition and therefore they are not liable to? On that, do you want to make any submissions?
So far as that part is concerned, lordship, because I am the wife of the deceased person, I am the claimant. I lodged an FIR where I have categorically mentioned something. It is on record, and in charge sheet also it is reflected. So on the basis of that, the court passed that order. So it is up to your lordship, where because the learned trial court didn't mention about the fact that pay and recover part. For that only the insurance company is agreed. Otherwise, if it was there, then they may not approach this honorable court. I am the claimant.
No.
I have a the
Tribunal considered that their submission
Yes,
and tribunal held that there was no pleading, neither there was proof
yes,
that there is a violation of policy conditions.
yes, that is there.
Regarding that observation of the tribunal, as the owner is not present,
Yes,
do you have any submission?
that part, lordship, it is a fact that in para 12 of their return statement, they have, although they have mentioned about the breach of policy condition, but they have not categorically, specifically mentioned about what breach of condition was that. It is not categorically mentioned in the return. For that purpose, only in the impugned judgment also, it was observed by the trial court that they have not took that particular plea of breach of policy condition in their written statement. That was the judgment. But I cannot argue on behalf of the owner. But as a claimant, what I found that, lordship, that I have my humble submission before lordship is that the offending vehicle has had a valid insurance policy with a third party insurance, and I am liable for that payment as per that third party liability. Insurance is liable to pay to me, and lordship may kindly decide the pay and recover part, because that is not mentioned in the impute judgment.
You have any submission? You are also,
The sister of the deceased person.
is also getting benefit.
Yes, yes, it is there. It is there in the judgment.
Okay.
Total amount, lordship. Actually, she is the unmarried sister of the deceased person, my husband's unmarried sister.
Okay, okay. Any reply? Mainly, we have to decide that whether the tribunal, by holding in paragraph number 12, that there is no pleading or proof to the effect that there was a violation of policy condition, was correct or not.
Yes,
And that is your contention also.
yes, that is my contention, because lordship, it is totally wrong when charge sheet is accepted by the court without any objection. There was no objection to the exhibited documents by any party. And when we adduced evidence, there also it was not objected to. And in the FIR, two documents, FIR and charge sheet. Otherwise, the other documents are postmortem report. And so, lordship, we are not denying that he did not die. There was a postmortem report, and also about.
But you are saying that if you have to pay and then after recover, then Nanjapa should be followed.
That is what I'm saying. But he has showed certain judgments, lordship, when our High Court itself said, okay, you first pay and then you go for the recovery. And lordship, I have given Shamanna last part, lordship, para 13. So far as recovery of the amount from the owner of the vehicle, the insurance company shall recover as held in the decision in Oriental versus Nanjappan and others. So that is there, lordship, para 13. For the purpose of recovering the same from the insurer shall not be required to file a suit. It may initiate a proceeding before the concerned executing court as if the dispute between the insurer and the owner was the subject matter of determination before the tribunal, and the issue is decided against the owner in favor of the insurer.
Where is the insurance policy? Oh, it prescribes a limitation for hire and reward.
Yes, lordship. I have annexed, lordship, with my appeal memo. It is at page 18, lordship, annexure 4. It was exhibited, but here we have a ready reference. Limitation to use, lordship. Last time I pointed it out, lordship. Lordship got it? The policy. So, lordship, on both sides, judgments are there. I have our High Court, Purnima Kumari, Sonali Kolita, because my friend has shown certain judgment, Putali Das, Nilima Bala. All these judgments, lordship, say that as per Nanjappan, lordship. And Balu.
And which is the relevant paragraph in Nanjappan's case?
Nanjappan. Para 8, lordship, down below. Para 8. Para 8, lordship. From down below, I suppose lordship will go to 6th line. So, the executing, it starts with the executing court will. I lost somewhere my copy, lordship. Lordship got it?
Okay.
And Apex Court Lordship, Balukishan Chauhan judgment is also there, wherein Apex Court held that at para 8 Lordship. On this aspect, the law is well settled that if liability of the insurance company is decided and they are held not to be liable ordinarily, there shall be no direction to pay and recover. However, in the facts and circumstances arising in each case, appropriate orders are required to be made by the court to meet the ends of justice. So Lordship has seen both sides, that first, some cases are there where Nanjappan is applied, that first we will deposit and then a notice will go to the owner and then the amount will be released to the claimant. And there are certain cases where the court held that no, you pay, then you recover. So it is up to Lordship to decide whatever.
What is the purpose of issuing notice to the owner? What purpose of that period of halt in Nanjappan? Why that direction was given?
So that Lordship, the insurance company is also secure.
Suppose notice is not served.
That is why Lordship, that's why I'm saying Lordship, that there are two ways of looking into it. He has shown certain judgments where the court said, ki, no, you pay and then recover. And in some judgments which I have mentioned of our High Court Lordship, should I give those copies?
No.
It
I
will be-
just wanted to understand the underlying principle. To my understanding is that one principle is that if the policy is valid policy. Second principle is that if, as the entire scheme is for the benefit of third party sufferer, and it is a benevolent legislation, therefore he should not suffer.
And that is why both sides, Lordship. One is just to protect the insurance company, that they get there, but still they won't be getting, because Lordship, there will be as per Nanjappan, the vehicle will be seized and it will be eventually. In fact, the law is that when a pay and recovery is there, that the insurance company will pay, and within 1 month, the owner has to deposit the amount before the tribunal. So that is in fact, the law.
Now, in this case, the owner is suiting, the appeal is proceeding ex parte.
But deposit will be before tribunal, Lordship. Since there will be recovery, because High Court is not the recovering court, Lordship. So Lordship cannot direct a recovery proceeding. We have to deposit, Lordship will direct us to deposit before the tribunal, and tribunal will release it to them. And in the meantime, the tribunal will be sending notice to the owner of the vehicle and also sees whatever his movable, immovable properties are there to satisfy. Or else if he submits the amount, deposits the amount, then no issue. Then it ends there.
No, whether you have to initiate a separate proceeding against owner.
We do not have. All the cases are clear. No separate in the same, we will be depositing before the tribunal in the same case, and in the same case, the notice will go to the owner.
Okay.
Rest of the part of Nanjappan is very clear, Lordship.
May I submit, if you Lordship allow me? Nanjappan case is 2004 and Manwara Khatun is 2017. For a moment, if your Lordship will allow me to, if your Lordship, I have already placed a judgment of our High Court, MSC Appeal 36 of 23. 36 of 2023 Lordship. MSC Appeal, it's a printout copy of.
Yes.
36. Party is name Oriental Insurance Company Limited versus Sahidul Islam. Lordship got it?
Yes.
Paragraph number 18 is important, Lordship. May I read, Lordship?
Yes.
Para 18.
Yes.
None of the judgment of the Honorable Apex Court discussed herein above, which are subsequent to the judgment passed by the Honorable Apex Court in the case of Chela Barathama Supra, held that furnishing of security by owner is a condition precedent for applying the principle of pay and recovery. In the considered opinion of this court, though furnishing a security may be desirable, but the same cannot be insisted upon as a strict condition in all cases. Further, this court is of considered opinion that the direction of furnishing security was issued in so-and-so Salavatama is in the given fact of the said case. Otherwise also, if such security is strictly insisted, the object of principle of pay and recovery as upheld in the judgment of the Honorable Apex Court as discussed herein above shall become meaningless.
What is the object?
Okay. In this case also, Lordship, this Honorable Court directed the insurance company to pay the amount and thereafter recover. Because it is Sala Barathamma is also 2004 judgment. The Supreme Court, I have that copy. If your Lordship want to peruse, then I can place before Lordship. Like Nanjapam, in this case also some conditions are there. So this is the observation of this Honorable Court, and I have also placed before Lordship the Manwara Khatun, where it is clearly mentioned that you pay first and thereafter proceed for recovery.
But Shamanna is 2018 Lordship, August 8, 2018, wherein Nanjappan is again upheld. So that is why I'm submitting Lordship. After Manwara, that this judgment, Shamanna has come. Justice Ranjan Gogoi and R. Bhanumati passed the order.
Okay, I'll go through the judgments. Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. Bhattakur, P.P. Bhattakur, learned counsel for the respondent number
One.
one claimant, as well as Mr. R. Deka, learned counsel for respondent number 4. Where is the ex parte order proceeding?
Last order, Lordship.
It appears that by order dated 27/1/2026, this court directed that this appeal shall proceed ex parte against respondent number 2, as in spite of, as the said respondent failed to appear, said respondent or his engaged counsel failed to appear before the court when the appeal was called on for hearing. Stop. Next para. This appeal under, you may take your seats. This appeal,
Judgment, Lordship, Balu Kishan.
this appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 17/9/2015, passed by the Additional District Judge number 3, Kamrup, in MAC case number 1060/2013, whereby the appellant was directed to a compensation amount of rupees
19,58,000.
19,58,000 to the claimants, along with an interest at the rate of 6% per annum from the date of filing of the claim petition till realization. Stop. The facts, next para, the facts relevant for consideration of the instant appeal, comma, in brief, are that on 8/3/2013 at about 1:35 AM, the husband of the claimant comma, who was proceeding in a vehicle bearing registration number AS 01 AK 7091 within bracket Maruti van from Gauripur to Dekiajuli, comma, to attend a marriage, met with an accident. Stop. It is stated that the said vehicle was suddenly hit by a truck from backside. Stop. The husband of the claimant died on the spot as a result of the aforesaid accident. Thereafter, the claimant approached the Court of London Additional District Judge number 3, which was also taking up MAC cases at that point of time, comma, by filing an application under section 166 of the MV Act 1988, seeking compensation for death of her husband in the aforesaid vehicular accident. Stop. The said claim case was registered as MAC case number 1060/2013. The truck was not made a party.
Whereas in fact, it was the offending vehicle. Because it hit from the backside.
The present appellant, which is the insurer of the Maruti van, contested the claim along with the owner of the said van by filing written statement. The driver of the aforesaid vehicle did not contest the case and it proceeded ex parte against him. Stop. On the basis of the pleadings of the parties, the claims tribunal / court framed following issues. Court A from page number 7 of the memo of appeal. Stop. In support of her claim, the claimant examined how many witnesses? Sole witness.
Also.
Claimant examined herself as PW1 and exhibited certain documents. The insurance company examined one Shri Drijen Datta, as its witness and exhibited the insurance policy as Exhibit 1. However, after conclusion of the inquiry by the impugned judgment and award, the present appellant was directed to pay the compensation to the claimants in the manner as described in the foregoing paragraphs. Stop. Miss R.D. Majumdar, the learned counsel for the appellant insurance company, has submitted that the tribunal has erred in directing the present appellant the payment of compensation amount to the claimants after compensation amount to the claimant. She submits that during the inquiry, the insurance company took a specific plea in their written statement that there was a violation of the policy condition by the owner, and as such, the insurance company is not liable to indemnify the owner, even in case the owner was found, no, in case the owner was found liable to pay compensation. She submits that in the charge sheet which was filed in connection with the case which was registered after the accident and which was filed against the driver of the Maruti van. It has been specifically mentioned by the investigating officer that the vehicle was taken on hire by the husband of the who is the claimant? Chandraprabha.
Chandraprabha is the claimant.
By husband of the complainant. She submits that in the insurance policy there is a clear stipulation to the effect that clear stipulation indicating the limitation as to the use of vehicle during the period of insurance cover. She submits that the policy covers use of vehicle for any purpose other than hire or reward and certain other conditions. She submits that as hiring of the vehicle was specifically prohibited by the conditions of the policy itself. The insurance company could not have been made liable to indemnify the owner as there was clear violation of a stipulation of the insurance, a violation of a condition of the insurance policy. She further submits that in paragraph number, which paragraph, WS?
12.
In paragraph number 12 of the written statement filed by the present appellant before the insurance company, it has been categorically pleaded by the insurance company that where is the WS?
At page 15, relevant paragraph 12.
It has been it was specifically pleaded by the insurance company that it would not be liable to indemnify the owner if there is any violation of the policy condition. She, however, submits that the tribunal had
Para 19.
erred in observing in the impugned judgment and award at paragraph number 19, no, impugned judgment and award within bracket paragraph number 19, that there was no pleading by the insurance company to that effect. And the fact that it was used in commercial purpose has not been established. She submits that when it is apparent from the uncontroverted documents relied upon by the claimant, that is the charge sheet, that the vehicle was taken on hire by the deceased from the owner. There was no requirement of adducing any further evidence by the insurance company. You adduced evidence, what he said.
In the judgment, it is written, Lordship. At para 17, Lordship. The husband travel in the hired vehicle. The claimant exhibited on the Jahar. The claimant has written that the husband travel in a hired. Paragraph 17. On perusal of record, it appears that on 24/2015, the claimant filed her evidence in chief in the form of affidavit, and on that day she was crossed. The claimant exhibited some document. In the Azahar Exhibit 2, the claimant had written that her husband traveled in a hired vehicle, and the investigating officer mentioned that in the charge sheet. So the insurance company came to know that the vehicle was allegedly hired on that day. So the company could have applied for filing additional return statement. That is the court say. Instead of doing so, the administrative officer examined him on 5/8/15, and on that day he stated that the owner of the offending vehicle violated the condition of the policy. In the cross-examination of DW1, it appears that the investigator of the company examined the owner and driver of the offending vehicle, but he has not furnished the statement of owner and driver in the court. So it is not known whether the owner and driver had admitted the fact that the vehicle was used in commercial purpose or not. DW1 in his cross-exam has admitted that in the written statement of the company, it does not mention that offending vehicle was used in commercial. So his DW1 deposition is beyond the pleading. That is the finding.
Last line.
And before that, in paragraph 16 is the submission.
However, the insurance company still adduced evidence of one witness who is the administrative officer of the insurance. Administrative officer where who is your witness?
Dijen. Dijen.
Who is the administrative officer of the company, who also deposed that from the charge sheet, the insurance company came to know that the vehicle was lent on hire by the owner, and thereby a condition of policy, insurance policy was violated. Chief learned counsel for the appellant further submits that in view of the clear in view of the materials available before the tribunal, which clearly indicated that there was a violation of policy condition, the insurance company could not have made liable to indemnify the owner. She further submits that even if insurance company is made to pay the compensation as awarded by the tribunal to the claimants, it may be allowed to recover the same from the owner in accordance with the guidelines laid down by the Apex Court in the case of Oriental Insurance Company Limited versus Sri Nanjappan and others, reported in 2004, 13 SCC 224. She has cited, no, she has also submitted that in later decision of the Apex Court in the case of Shamanna and others versus Divisional Manager, Oriental Insurance Company Limited and others, reported in
Give the SCC number, Lordship. This is reportable 2018
2018
9 SCC
9 SCC
650.
650, 2018 9 SCC 650, which has approved the guidelines for pay and recovery to be made by the insurance company, as was observed in the case of Nanjappan's case. So, stop. She, however, submits that the insurance company does not have any she does not have any submission contrary to the fact that, no, continue. She, however, submits that the fact of the accident is not challenged by the insurance company, neither the quantum of compensation awarded by the tribunal, and therefore she submits that if this courts direct the appellant to pay the compensation, it may be allowed to recover the same from the owner in terms of the directions of the apex court in the case of Nanjappan versus, in the case of Oriental Insurance Company Limited versus Shri Nanjappan and others. Sopra. Stop. Mr. P.P. Bodhakur, on the other hand, Mr. P.P. Bodhakur has submitted that since this appeal is mainly directed against the question of directed against the judgment of the tribunal directing the attributing the directing the insurance company to pay to indemnify the owner, and since the materials on record clearly indicate material on record, especially the charge sheet indicates that the offending vehicle was lent on hire by the owner in violation of the policy conditions. This court may decide as to whether you are not making any submission on that.
Yes, Lordship, because the offending vehicle has a valid policy and a third party coverage. So otherwise I'm entitled to.
This court may decide as to who has to pay the compensation. However, he submits that since the offending vehicle was under a valid insurance policy coverage at the time of accident, which provide for
The third party coverage.
the coverage of any damage or loss to third party. Hence, the claimants are otherwise entitled to get the compensation amount. He further submits that since the Motor Vehicles Act, since the relevant provisions of Motor Vehicles Act are benevolent provisions directed to benefit the innocent third party sufferers, the insurance company may be directed to pay the compensation to the claimants and thereafter recover the same from the owner. He further submits that the requirement of issuance of notice to the owner and prior attachment of offending vehicle before dispersing the amount the claimant as was prescribed by the apex court in its judgment in the case of Oriental Insurance Company Limited versus Nanjapan. Is not stick to by the apex court in its later judgment. He submits that in the case of Manwara Hatun and others versus Rajesh Kumar Singh and others reported in 2017 4 SCC 796, the apex court considering the benevolent object of the act and other relevant factors, issued direction to the insurance company to pay the awarded amount to the claimant and then to recover the same from the insured without any other additional conditions. He submits that a coordinate bench of this court has also keeping in view of the after considering the judgments of the apex court as well as considering the fact that there was a valid insurance policy at the time of the accident, directed the insurance company to pay the compensation to the claimant and thereafter recover the same from the owner. Within bracket cases like the Oriental Insurance Company Limited versus Jatindranath Deka and others. MAC appeal number 472/2017. Judgment dated 28/4/2022. Next, number 2. Oriental Insurance Company Limited versus Shahidul Islam and others. Within bracket MAC appeal number 36/2023. Judgment dated 3/2/2023. Anything else?
Lordship, my learned friend relied upon recently on Shamanna and another, where the Honorable Apex Court in 2018 relied upon the Nanjappam case. Recently, I just go through the para number 14 of the judgment. Shamanna and another. Lordship already recorded that part in the submission of my learned friend, where in para number 14, my lord, the Honorable Apex Court emphasized only in para 8 of the said Nanjappam judgment.
The judgment is with me.
Yes. For a moment, Lordship may kindly peruse para 14 of the judgment.
Yes.
Page 226, para 8. And it is under quote unquote, Lordship. Para 8 is already For the purpose of recovering the same from the insurer shall not be required to file a suit. It may be initiate a proceeding before the executing court concerned as if the
Okay, okay.
that part only, not
Well,
like for other strict condition, Lordship. The Samanna is also in my favor, my lord. Because Honorable Apex Court said you pay, then recover.
No, no.
Last paragraph.
well,
Para number 15.
Which para you were referring to? Para 8?
Para 14 of the judgment, Lordship.
Shamanna's judgment.
Yes, Samanna's judgment, para 14, where
Yes.
the Honorable Apex Court observe about the emphasize on Nanjappam case. In Nanjappam case, para number 8, Lordship. Para 8 of Nanjappam case. There only how to proceed is only mentioned, not like other strict condition for executing bond or seizure of recovery of the vehicle. Those are not mentioned here in Samanna.
No, what is the difference between Nanjappa and other cases? The only difference which I see is that before disbursing the amount to the claimant, it has to ensure that notice is served on the owner, then the vehicle is seized so that it can recover. And in other cases, no such stipulations are there. It has to pay to the claimant, and therefore, thereafter it will proceed before the executing.
But court lordship, other judgments are there wherein that Nanjappan is followed, coordinate bench judgment of there. I will give lordship and
Give those numbers.
numbers, yes, lordship.
Appellant or submission of Lekibo. Appellant or submission of learned counsel for the appellant has also submits that the coordinate benches of this court has, while directing the insurance companies in cases before it to pay the compensation to the claimant and thereafter recover the same from the owner, has followed the directions of Apex Court in the case of Nanjappan in following cases. Number 1.
One MSC appeal 134 of 2020.
Next.
Next lordship, Chala Bharatam.
Citation to Lelo.
Oh, it will edit by jabo.
Yes, you just tell the.
Then Chala Bharatama was followed in the MSC appeal 467 of 2017.
Okay. I'll go through these judgments and dictate remaining part later on. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also considered I have also gone through the rulings cited by learned counsel for both sides in support of their submissions. Stop. Hearing concluded, judgment reserved.
One more MSC appeal, Madam Likibo Pare. MSC appeal 168 of 2020. Because lordship, these are also my cases, whatever he's citing, those are also my cases. So lordship will ultimately decide what lordship wants.
My only submission before Lordship is that Lordship will definitely consider one part. Accident took place in 2013. At that time, I was pregnant, and after the demise of my husband, I gave birth to a child. The thing is that since then, after filing of the case, till that I have not received a single penny.
You have not received anything.
In fact, at the time of admission of the case also, they have not paid anything. The matter is not stayed. This submission is not necessary at the time of final hearing. Even then, the impugned judgment was not stayed. My learned friend filed an execution petition there for but they have said that matter is sub judice there. I don't know what happened in that trial court execution. But the thing is that the lady the lordship may kindly consider a part of the litigation. If this honorable court, as per their submission, allow the insurance company that you pay, but before disburse the amount, issue notice to the owner. When the owner received the notice from this honorable court, but that from the tribunal, he again approached this honorable court that the proceeding was ex parte. He blamed his lawyer and everything. And thereafter,
I'm supporting him, Lordship.
then
I'm
I will not get the
but
money
I'm
for
just-
another 10 years, my
No,
lord.
I am just submitting, Lordship, what are the judgments? I am supporting him. It is.
No, you want Manwara to be followed.
Yes.
That immediately they
Yes,
will
yes.
pay and they will
I may
there.
withdraw the amount and they may proceed with the proceeding with the owner. I have nothing to say, lordship.
And Lordship, 25,000 statutory deposit may be allowed.
Okay. Okay. Hearing concluded, judgment reserved.
Deposit, Lordship, before the tribunal.
Okay.
No issue. That's the problem. No?
Oblige, lordship.
Highly obliged. Itu likhi se to para 25.
No, he is also entitled to, as per the, we are not disputing on that. He is, that client is our relative, my husband's sister, unmarried sister. She is also entitled as per the judgment. We are not disputing.
She was also claimant along with you.
Yes, yes, yes. Subsequently.
It is given at page para 25, Lordship. Lordship mentioned it.
It is there, it is judgment.
It is
We are
there.
not disputing.
Apportionment is there.
Yeah, I'll go through it.
Yes.
Para 25.
After you deposit it, it will be apportioned
As per this.
as per the,
25, 26, 27.
it will be dispersed as per the
Yes.
tribunal's judgment.
Original,
Yes, yes,
original.
yes. I'm not, no objection.
She gets 450. And 450 for
Her
minus son.
entitlement is 4,50,000 rupees.
Son is 450. And Prabha is 10,58,000. And 6% interest.
6% payment.
Go file korane cholte.
Okay, judgment reserved.
Highly obliged, Lordship.
There is a judgment, lordship, that without filing an appeal, this honorable court has the power and jurisdiction to enhance the 6% to 9%. So we'll object definitely. Just that.
Ranjana Prakash is there, Lordship. It cannot be.
We
Unnecessary.
will not go into those issues.
I will not face it. Oblige, highly oblige.
Item 9.
Wait, this is your Lordship. Here, Lordship, we are two insurance company. I have also prepared a written argument. I think I submitted it earlier also. The deceased himself was driving the vehicle, Lordship. And it is settled law that but Lordship, before that, Lordship, the claimants here, Mr. Wise Imran used to appear in the case.
Oh.
Mr. Wise Imran advocate, but
Oh.
later on he stopped appearing. So, Lordship, I do not know if Lordship will take up the hearing in absence of
Claimant is not there.
claimant is not there. Dada is appearing for the other insurance.
I've satisfied my part of the.
You have satisfied. You have already paid.
Because
And why you are objecting?
because deceased was owner of the vehicle which he was driving.
So you are denying liability itself.
Yes, denying the liability. And it is settled law. I have judgments of our High Court as well as Apex Court on that. On that point, Lordship.
There was some typographical error perhaps in the last order. You submitted that this is not a fit case for hearing.
This is not a fit case for mediation, maybe.
that could be-
Lordship.
Yes, it, no, we'll issue notice, at least once we'll issue letter.
I thought, Lordship,
Issue.
that's why I didn't want to start it.
Who was appearing,
Mr. Wise Imran, Lordship.
is he coming to the court?
No, not now. Not. So, Lordship, let the registry send a notice to the. Instead of us sending, let the registry send a notice. That will be faster.
Wisely stated.
Easier about the whole appear no correction.
Yes, wisely stated. Wisely.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. R. Goswami, learned counsel for respondent number
Five.
5. None has appeared for the claimant respondent.
One and two.
Number 1 and 2. It appears that the judgment and award dated 1/4/2011 passed in MSC case number 60/2019 by the Motor Accident Claims Tribunal Tinsukia has been impugned in this appeal by the appellant. By the said judgment and award, the present appellant as well as respondent number 5 were directed to pay a compensation amount of rupees 14,49,500 to the claimants, along with an interest at the rate of 6% per annum. Stop. Though the insurance, your insurance company is Miss,
New India.
though the New India Insurance Company, that is respondent number 5, has already paid its share of the compensation to the claimant. However, present appellant is agitating its liability to pay compensation on the ground that the deceased was himself the owner of the offending vehicle. Stop. It also appears that this is an old pending appeal of the year 2012, and the appellant was, and the claimant respondents were earlier represented by their engaged counsel, namely Mr. W. Imran. It can be reflected that he has stopped coming to the court.
Yes, Lordship. Can be no.
Learned counsel for the appellant has fairly submitted that said counsel, Mr. W. Imran, has stopped coming to the court. It also appears from record that on last many occasions, nobody has represented claimant's respondent. Under such circumstances, as the right of the claimant's respondents may be affected as the outcome of this appeal, this court intends to give an opportunity to the claimant's respondent to, before proceeding with hearing of this case. Accordingly, the registry of this court is directed to issue notice to the respondent number
1 and 2.
1 and 2 by speed post as well as by usual mode. Returnable on 22nd of April. Release this matter accordingly.
Highly obliged, Lordship.
Item 10.
This please, Lordship. Lordship, I am appearing for respondent number 1 and 2.
Yes.
May it please, Lordship.
Yes.
Lordship, I'm for the appellant Lordship. Lordship, the appeal is filed by the appellant to stay the or judgment and order dated 7/11/2000.
No, not stay petition. The main case, main appeal.
Lordship.
We are not taking up the IA. We are taking up it is fixed for hearing.
Lordship.
So we'll hear the appeal.
In appeal, I have Lordship, two facts, Lordship, regarding the non-consideration of the cover note issued by the insurance company. In the judgment, Lordship, although cover note has been discussed, but it has not been considered.
What is your case?
Lordship,
You are insurance company, na?
no, Lordship. We are from the agriculture department, Lordship.
Okay.
The vehicle was purchased by a beneficiary group, Lordship, availing the subsidy of the subsidy given by the department, Lordship. In the registration certificate, director of agriculture was the name was inflected. Thereafter, Lordship, beneficiary group has possessed the vehicle, and accordingly, insurance has made, Lordship.
Who is appearing for insurance company?
No one is appearing, Lordship.
Although
Notices were issued.
does the service already done, Lordship, but they have not appeared.
Respondent 4, Cholamandalam General Insurance Company, they have not appeared. Service is complete, Lordship, but they have not appeared. They were in the trial, but in the appeal they are absent. And the driver was absent in the trial, but the driver is present before this honorable court.
Who is
the respondent number 3?
Who is representing?
They have filed a wakalatnama, Lordship, but I'm not representing. Someone else is representing. One HB Gauhati, someone has filed a wakalatnama on behalf of the driver. Respondent 3, Kamal Ali. You know, the accident was caused by a tractor that was purchased by the Director of Agriculture in the name of a self-help group. The initial purchase registration was done in favor of the Director of Agriculture, the RC registration certificate. That has not been executed, Lordship. There is only a copy in the lower court record. I also have a copy. The name is reflected, Director of Agriculture. So in the Director of Agriculture's name also finds mention in the Form 54, Accident Information Report. So as a claimant, I showed him as the owner in the claim, Lordship. So the insurance was disputed by Cholamandalam Insurance Company. They told that the insurance does not cover the date of the accident. But there was a cover note that preceded the insurance policy. The insurance policy, Lordship, was with effect from 12 May 2012 to 11 May 2013, and the date of accident was 3 May 2012, just prior to 9 days from the validity of the insurance policy. But the cover note date is 2 May 2012. That is 1 day prior to the date of accident. So there is a coverage for the of the policy through the cover note. And this cover note, Lordship, it has not been executed before the trial court. But this cover number finds mention in the insurance policy that has been executed.
Lordship, there is a fact, Lordship. in as per the MOU, the vehicle was handed over to the self-help group. And accordingly, the self-help group has insured the vehicle, Lordship. And in cover note and insurance documents, the secretary and the president's name was clearly mentioned in the these documents, Lordship. Kindly go through the page number 34, Annexure 4, Lordship. Cover note.
The page number 35 is the insurance certificate. Here also the cover note number is stated.
Let her submit.
Lordship,
Let her.
cover note has been in Central Motor Vehicle Rule 1989. The cover note has been described in Rule 142, Lordship.
Motor Vehicle Act.
And cover note is a temporary insurance document which is issued by the company until the completion of the process of the final insurance.
Which rules provide for cover note?
Load 142, Lordship. Cover note. Sub-rule 1. Every cover note issued by an authorized insurer shall be in Form 52.
Motor Vehicle Act with rules.
Rules. Settlement.
Rule, which one?
Rule 142, Lordship. Cover note.
One 42 of which rule?
Sub-rule 1, Lordship.
No, which rule? Central Motor Vehicle Rules.
Central Motor Vehicle Rules 1989.
Yes. Yes, please.
Sub-rule 1. Every cover note issued by an authorized insurer shall be in Form 52. Sub-rule 2. A cover note referred to in Sub-rule 1 shall be valid for a period of 60 days from the date of its issue. And the insurers shall issue a policy of insurance before the date of expiry of the cover note. Kindly go through the cover note, which is Annexure 4, page number 34.
Well, what is a cover note?
Cover note. Cover note is a
Where is the definition?
temporary insurance document, Lordship.
Where is that?
Explanation is not there.
That this is a temporary insurance document.
Lordship, because in main policy, Lordship,
No, where is the definition of cover note?
Lordship, actually, definition of validity of cover note is
Because your case is based on cover note.
Lordship.
So what is cover note? that legal definition is necessary.
Normally, Lordship, cover note used for a temporary insurance coverage, Lordship.
No, that is. You find out, we'll proceed ex parte against the, there is no order of proceeding ex parte against the other respondents.
Lordship, I rely upon the apex court judgment on the basis of the cover note, Lordship.
What it says.
Lordship, it says the cover note insurance was commenced from date of 1/5/2012, Lordship, and it covered up to 1/5/2013. Accident was happened 3/5/2012. It means within the within the cover period, Lordship. And in the cover note, it is the payment mode is case, Lordship. And in the
No, my query is, when the phrase cover note has been used in rule 142, somewhere it must have been defined.
Lordship, I'll verify, Lordship, kindly. I have to rely upon Supreme Court judgment, Lordship, 2009-13 SCC 370.
No, you first answer my query,
Lordship.
then go to the judgment.
Lordship, I have kindly give some time, Lordship.
You find out. In the meanwhile, there is no order of proceeding ex parte against the other respondent. That order will pass today.
If the IA will be taken up, Lordship.
No, we'll fix
For final.
next Tuesday or Thursday, short date.
Lordship, till that, Lordship, some time will be given, I will satisfy your Lordship.
What is your case that if we go by cover note, the vehicle was insured on the date of accident?
In the Supreme Court says that insurance company cannot issue a policy unilaterally from a future date without the consent of the holder of the policy. That is one of the aspects, Lordship. Other aspect is
Which is the judgment?
Bulby Core and others versus New India Assurance Company Limited and others. 2009-13 SCC 370, Lordship. In a case, Lordship, insurer, they cannot without the consent of the insurer, Lordship, insurance holder, they cannot change the date, Lordship. In that case, Lordship, they have changed the date in the insurance policy. Insurance policy clearly note that insurance policy is issued in lieu of the cover note, Lordship. In the insurance policy, it is clearly stated, Lordship. And other fact is that, Lordship, because insurance, we are not the holder of the insurance policy, Lordship. Insurance policy was held by the self-help group, Lordship. Self-help group is not in the party, Lordship. It's a necessary party.
Lordship,
So, Lordship,
self-help group is just a agent of the principal, the
Lordship,
Director of Agriculture.
Lordship,
The
No,
Director of
you-
Agriculture bought the tractor.
No,
and
we are
gave to
not
the
going
self-help.
into those issues. Your contention is on twofold. First of all, that it is covered by insurance,
insurance company, they cannot
escape their liability.
their liability. And on the basis of the document, they have insured this vehicle, Lordship.
Okay. And second is,
Second is that,
otherwise also you are not the owner.
Lordship, yes, because already MOU is there and Lordship, they have not made the party. And
Who
second,
is shown as owner of the vehicle?
Lordship, registration card was in, of course, in the name of our Lordship.
Then you are.
Lordship, but in case also, Lordship, they have not included the necessary party, Lordship. Because the
Okay, no, you find out this concept of cover note.
Lordship.
Lordship, cover note is just temporary arrangement until the policy is.
Where from?
Lordship, I will from the next day I will submit all the materials.
Heard Miss G. Bora, Learned Standing Council, Agriculture Department. appearing for the appellant. Also heard Mr. What is your name?
S Saha,
S. Saha appearing for respondent number
R1 and 2.
1 and 2. It appears from order dated 28/3/2025 that this court has held that the service on other respondents is complete. However, except respondent number 1 and 2, no other respondent is represented before this court today, including the respondent number 4, that is the insurance company. Respondent number 4 is the insurance company. Stop. This appeal shall, therefore, proceed ex parte against the absentee respondents. Stop. During the course of hearing, a query was posed by this court to the learned counsel for the appellant as to what is meant by a cover note of the insurance policy, as the said phrase has been used in section 1 in rule 142 of the Central Motor Vehicle Rules 1989. Stop. On this, learned counsel has sought some time to answer to the query posed by this court. The prayer is allowed. Let this matter be listed 24th of March.
Public.
Item 11.
May please your lordship. Lordship, here, the impugn award is of rupees 1,70,000. And it was directed to be paid 60% by the appellant and 40% by the respondent number 2.
Both are insurance company.
Both are insurance company. They have paid. And they have, and against.
We have
I
also paid
filed-
25,000.
They have paid 25,000. When the stay was granted, at that time 25,000 was paid. And I have also preferred a cross appeal. That was admitted
For enhancement.
for enhancement. So let I begin now.
What is your ground?
Lordship, the expenditure was as per court's own
No, what are the facts?
facts. I'll read the judgment, Lordship. That will be making the whole fact more clear, Lordship.
Yes.
Lordship, today morning heard a ration negligence case, so this will be again enlightening. The vehicle comes from backside and hits the standing truck, and the court makes the truck 60% liable and the vehicle 40% liable, the insurer of the vehicle. So I'll just read the judgment.
But before that, little gist, what are the facts?
Injury case, Lordship.
Injury
She filed-
case.
Yes, she filed the case where she was traveling in a vehicle and that vehicle dashed against a standing truck.
Standing truck.
Standing truck.
You are the truck,
Truck.
insurer of the truck.
And my brother, he is
Why,
insurer.
why you filed this appeal?
Appeal, Lordship, the court has given a lump sum amount of 1,50,000 as medical expenditure, whereas the medical expenditure should be as per actuals. 25, that was 28,689. And also that the ration negligence, Lordship, the amount attributed, 60% attributed to the truck is not correct. We have come against that also. Question is not of how much amount, Lordship, that what my friend is trying to harp on is that there is a very less amount, that is not the question. But if expenditure in a injury case is 28,689, can the court give 1,50,000? That is the
So
question. That is
this,
so many percentage of increase
okay, the basis,
basis.
there was no basis for,
1,50,000, and again, total was 170 given. 20,000 submitted. I'll read the judgment, Lordship. It will be clear how the accident took place. Lordship, the judgment in my memo of appeal starts at page 7, but main judgment starts at 8. The instant case has been filed under section 166 of the Motor Vehicle Act, in short MV Act, by the claimant Srimati Saraju Bora, wife of Sri Paresh Bora, resident of Tengla Gaon, under Kamargaon Police Station, District Golaghat, Assam, claiming compensation from the opposite parties. Sri Chand Singh, son of late N. Singh, care of Sinha Roadways, Sevok Road, PO Siliguri, District Darjeeling, West Bengal, the owner of the vehicle bearing registration number so and so truck, Sri Krishna Rai, son of Sri Bijuli Rai of Sevak Road, Siliguri, District Darjeeling, West Bengal, the driver of the said trucks number so and so, the manager, Oriental Insurance Company Limited, CVO 1, Siliguri, the insurer of the aforesaid truck number so and so, Sri Paresh Bora, son of late Ratneswar Bora of Thengal Gaon, PO Kamargaon, District Golaghat, Assam, the owner of vehicle bearing registration number so and so, I-20 car, Muhammad Faizul Ali, son of Muhammad Tayyib Ali. These are all names, Lordship. I'll go down. The insurer of the manager, Bajaj Allianz General Insurance Company, Guwahati branch, Guwahati, the insurer of aforesaid I-20 car number so and so, to the tune of 9 lakhs on account of injury sustained by her in a motor vehicle accident that took place on 3/10/2013 at about 2:45 a.m. near Santipur on NH 37 under Dergaon Police Station, District Golaghat, Assam. The claimant in her claim petition has stated that on 3/10/2013 at about 2:45 a.m., she, along with her other family members, were traveling in the vehicle bearing registration number so and so towards her home from Sipsagar. And while they reached near Santipur on NH 37 under Dergaon Police Station, the said I-20 car in which she was traveling dashed against the backside of a stationary truck bearing registration, and as a result, she sustained severe injuries on her person, and the vehicle also damaged badly. After the accident, the injured claimant was taken to Sanjeevani Hospital, Jorhat, and treatment there as indoor patient for 5 days till 7/10/2013. Thereafter, on 15/10/13, the claimant was taken to Chandraprabha Eye Hospital, Jorhat, for treatment of his eye injury as an outdoor patient. As she did not recover from the injury sustained by her, she was again taken to Dr. Sri Sajjadur Rahman, eye specialist, Golaghat, and the doctor referred her to a better eye hospital for further treatment. Accordingly, on 23/10/2013, the claimant was taken to Mechi Eye Hospital, Nepal, and took medical treatment there till 25/10/13 as outdoor patient. As the injured claimant did not recover from the injuries sustained by her, she again went to Nemcare Hospital, Guwahati on 7/1/2014 for the treatment of her injured right hand, and thereafter she was undergoing her medical treatment from her home with periodical medical checkup. As a result of the accident, the claimant sustained permanent facial disfiguration. It is also stated that at the time of accident, the driver of I-20 car so and so driven his vehicle in a normal speed by observing all the traffic rules and regulations. On the other hand, the vehicle bearing registration number was in a stationary condition on the road without flashing any signal light and road barrier in the night hours. On receipt of the notice from the tribunal, the OP number 3, 4, and 6 entered appearance and submitted their written statement. In spite of receipt of notice from this tribunal, the OP numbers 1 to 5 failed to turn up to contest the case, and therefore the claim petition against them has been decided to hear ex parte, and accordingly it is heard ex parte. In its written statement, the OP number 3 has stated that the claim petition is not maintainable in law as well as in fact, and there is no cause of action to file the claim petition, and there was no rash and negligent driving on the part of the driver of the vehicle number so and so truck, and the accident took place due to rash and negligent driving on the part of the driver of vehicle number I-20 car and dashed against the backside of the truck, and the claimant never sustained injury in the alleged accident, and the claimant's claim is exorbitantly high, arbitrary, and without any material basis, and it is speculative in nature, and therefore it is contended to dismiss the claim petition. In the written statement, the OP4 has stated that there is no cause of action to file the claim petition, and the claim petition is bad for non-joinder of this answering opposite party, and that the amount of compensation as claimed by claimant is highly excessive, without any basis and speculation in nature, and that there was no rash and negligent driving on the part of driver of vehicle bearing registration number so and so I-20 car at the relevant time of alleged accident. And on the other hand, the accident occurred due to sole rash and negligent driving on the part of the driver of the vehicle bearing number so and so truck. And that at the time of alleged accident, the vehicle bearing registration number so and so I-20 car was duly insured with Bajaj Alliance General Insurance Company Limited by package policy number so and it was valid up to 7/12/13, and as such, in the event of any compensation awarded by the tribunal, then the said insurer shall have to indemnify the insured. In its written statement, the OP number 6 has stated that the claim petition is false and it is not maintainable either on fact or in law, and the alleged accident took place due to sole negligence on the part of the stationary truck bearing registration number so and so, which was parked without proper caution, and that the driver of the vehicle number ASI-20 car at the relevant point of time was not holding a valid and effective driving license, and that the amount claimed by the claimant is highly excessive, exorbitant, and exaggerated, and therefore it is contended to dismiss the claim petition. Upon pleading of the parties, following issues were framed to decide his claim case: whether there was any composite rash and negligent driving on the part of the drivers of vehicle number so and so truck and number so and so I-20 car that caused the accident on 3/10/2013 at about 2:45 a.m. near Santipur on NH13 under Dergaon police station in the district of Golaghat, Assam. Whether Srimati Saraju Bora sustained grievous injury as a result of the said accident, whether the claimant is entitled to any compensation, if so, what would be the proper quantum and payable by whom? Any other relief. The claimant in support of her claim has submitted her evidence in affidavit and exhibited the following documents: accident information report, prescription dated 3/10, the discharge certificate dated 7/10/13, prescription dated 15/10/13, prescription, medical expenditure statement of an amount of rupees 28,689. Lordship will mark this amount because this is the only amount that was spent.
Which,
That is 9. In that, Lordship, Roman 9.
yes.
Prescription dated so and so of Apollo Hospital Exhibit 10. The witness was cross-examined by the learned counsel for OP3, that is Oriental Insurance Company, and OP6, Bajaj Alliance General Insurance Company Limited. I have heard argument advanced by learned counsel for both sides. On the basis of evidence on record, the issues are adjudicated accordingly. Both the issues 1 and 2 are being interrelated, are taken up together for discussion. To arrive at a decision whether there was any composite rash and negligent driving in the part of drivers of vehicles number so and so truck and number so and so I-20 car that caused the accident on 3/10/13 at about 2:45 a.m. near Santipur on NH37 under Dergaon police station in the district of Golaghat, Assam, and whether the claimant Srimati Sarju Bora sustained grievous injury as a result of said accident. Let the evidence on record be discussed. In this regard, the evidence of CW1 makes the position clear that on the relevant date, that is on 3/10/2013, at about 2:45 a.m., she along with her family members were returning home at Thengal Gaon from Sipsagar in one I-20 car bearing registration number so and so after attending a marriage ceremony there. While they reached near Santipur under Dergaon police station, the I-20 car in which she was traveling dashed against the backside of a truck bearing registration number so and so, which was in a stationary position. This is important, Lordship. And as a result, she sustained fracture of nasal bone injury, multiple facial injuries, 6 stitches, right ball injury resulting low vision, deep cut injury over right palm, and foreign body entered in web between third and fourth finger. After the accident, she was taken to Sanjeevani Hospital, Jorhat, and treated there as an indoor patient for 5 days from 3/10/2013 to 7/10/2013. Thereafter, on 15/10/2013, she was taken to Chandraprabha Eye Hospital, Jorhat, for treatment of her eye injury. As she did not recover from the injuries sustained by her, she was again taken to Dr. S. Sajadur Rahman, eye specialist, Golaghat, and the doctor referred her to Gauhati for further treatment. Accordingly, on 23/10/13, she was taken to Mechi Eye Hospital, Nepal, and took medical treatment there till 25/10/2013 as outdoor patient. As she did not recover from the injuries sustained by her, she was again taken to Sanjeevani Hospital, Jorhat, and consulted with Dr. Chandra Bora, MS Surgery. Thereafter, again, she was taken to Nemcare Hospital, Guwahati on 7/1/2014 for the treatment of her injured right hand. And thereafter, on 16/4/2014, she was taken to Apollo Hospital, Chennai, and treated there as outdoor patient. And thereafter, she was undergoing her medical treatment from her home with periodical medical checkup. As a result of the accident, she sustained permanent facial disfiguration. The documents exhibited by the claimant, that is Exhibit 1, the accident information report, 2, prescription Sanjeevani. These are all again repeat, Lordship. The prescription of the various hospital also lends support to her version in respect of injuries sustained by her. Her evidence also reveals that at the time of accident, the truck bearing number so and so was in stationary condition on road without flashing any single light, and the road barrier in a no parking zone in the night hour. As such, the accident occurred due to rash and negligent driving on the part of the driver of the rash and negligent driving. This Lordship will mark that the court is writing about driving, Lordship, whereas the vehicle was in stationary position. The defense side has not disputed the injury sustained by the injured. The factum of wrong parking of the truck covering the national highway at Santipur under Dergaon police station remain unrebutted in cross-examination. Thus, it appears that the injured Srimati Saraju Bora sustained grievous injury on her person as a result of the motor vehicle accident that took place on 3/10/14 at about 2:45 a.m. near Santipur on NS 37 under Dergaon police station due to wrong parking of the offending truck bearing registration number so and so. The evidence of the claimant was clearly supported, has clearly supported the same. But at the same time, negligence on the part of the driver of I-20 bearing number so and so also cannot be ruled out, as because at the material point of time, the truck was in stationary position. Issues number 1 and 2 are decided accordingly in affirmative. Both the issue number 3 and 4 have been interrelated, are taken together for discussion. Now it is to be decided in the instant case whether the claimant is entitled for any compensation, and if so, what would be the proper quantum and payable. In view of affirmative decision in issue number 1 and 2, and in view of the fact that the claimant sustained injuries on her person in a motor vehicle accident, I am of the considered opinion that the claimant is entitled to compensation here in this case for the loss suffered by her. The claimant in her claim petition claimed an amount of rupees 9 lakh for the injury sustained by her in the motor vehicle accident. Though the claimant in her evidence in affidavit deposed that she spent about 1,20,000 for her medical treatment, including number of tests, X-ray, purchases of medicine, payment of doctor fee, nursing, cost of attendant, transportation, fooding, etc. But she has submitted the medical expenditure statement, which is exhibited as Exhibit 9 for an amount of rupees 28,689. This is important, Lordship. Excluding the cost of attendance, transportation, and fooding, enclosing thereby 14 numbers of cash memo and bill. In cross-examination of OP number 3, the claimant has stated that she has not submitted any disability certificate. From the document exhibited by the claimant, it reveals that the injured claimant took treatment in various hospitals, Jorhat, Gauhati, Golaghat, Nepal, and Chennai for the injuries sustained by her in a motor vehicle accident on 3/10/13 to 14/4/2014. Considering the aforesaid fact and circumstances, and also considering the present cost of medicine as well as other expenses, I am of view that the lump sum amount of rupees 1,50,000, this we are challenging, Lordship, as medical expenses, considering the vouchers, bills, etc. So, Lordship, the vouchers bill, Lordship, I already read are of 28,689. But the court is saying that considering the vouchers, bills, etc. submitted by the claimant in this case is just proper amount of compensation here in this case. Accordingly, a sum of rupees 1,50,000 is awarded as compensation to the claimant due to cost of her medical expenses For pain and suffering, I am of the view that a sum of rupees 20,000 may be given to injured claimant. According to the aforesaid calculation, I am of the opinion that it is a fit case to award the amount of rupees so and so 1,70,000 only as compensation to the injured claimant due to the injury sustained by her as a result of the motor vehicle accident. Now the question arose from whom the compensation amount should be recovered for payment of the claimant. From the record, I find that the accident took place with the wrong parking of the offending truck number so and so by covering the national highway at Santipur area, Dergaon, under Dergaon police station. The evidence of claimant has clearly substantiated the same. But at the same time, negligence on the part of the driver of I-20 car bearing number so and so also cannot be ruled out. Mention to be made here that the said truck was in stationary position. Therefore, would like to apportion 60% negligence on the part of the driver of vehicle number so and so truck and 40% negligence on the part of the driver of, if I may pause for a moment here, Lordship. The accident took place at 2:45 and naturally the I-20 had a headlight. It was dark, it had a headlight, so it couldn't see. They are giving importance to that. No parking light, I'll come to that also, that the claimant herself was sleeping at that point of time, Lordship. That the court has not mentioned. But if the car which is coming from a direction, it is not the case that the truck was in the middle of the road and even if the truck is on the middle of the road, the car coming from backside doesn't have the right to go and dash against it. And then the court comes to a finding that 60% is the truck, which is stationary position, and the vehicle coming from backside, it is only 40%. It also appears from Exhibit 1, the accident information report. At the relevant time, the offending truck bearing number was insured with OP3, the Oriental Insurance Company Limited, with package policy number so and so, and it was valid from so and so. And the I-20 bearing number so and so was insured with OP number 3, Bajaj Alliance, with package policy so and so, and it was valid from so and so. It also appears from Exhibit 1 that at the relevant time, the driver of the said truck, Sri Krishna Ray, had possessed a valid driving license bearing number so and so, and it was valid up to 23/2015. And the driver of the aforesaid I-20 car, Muhammad Faizul Ali, had possessed a valid driving license bearing number so and so, and it was valid up to 9/3/2023. The accident took place on 3/10/13, and as such, the insurance company policies of both the vehicles and the driving license of the drivers of both the aforesaid two vehicles were in force at the relevant time of accident. As such, it is the OP number 3 and OP number 6 who are liable to pay the aforesaid amount of compensation to the claimant at the ratio of 60 and 40, with interest at the rate of 6% per annum from the date of filing the claim petition till its realization. Issue number 3 and 4 are decided according to the result. The claim petition is allowed on contest. The OP number 3, Oriental Insurance Siliguri branch Siliguri so and so, and Bajaj Alliance are directed to pay the amount of 1,70,000 only to the claimant at the ratio of 60/40 along with simple interest 6% per annum from the date of filing the claim petition. So that was the judgment, Lordship. Now, just go to the cross-examination of the claimant. My first ground is that this, since 28,689 was the amount, total amount that she had spent, Lordship, the court could not have given 1,50,000 on account of medical expenditure, because those are to be actuals. Then my second ground is that, Lordship, the learned court below failed to consider that vehicle in which the respondent one was traveling hit the standing truck from the backside. No evidence of the driver of the vehicle in which the respondent one was traveling was adduced in the court to prove that the parking light of the truck was not on. The learned member in a perverse manner ignored the cross-examination of the respondent number 1, wherein she had admitted that she came to know from the driver that the parking light was not on. Thus, it is hearsay evidence. Lordship, that's why the cross-examination of
My lord, I am reading out
Which
the
line?
cross-examination part.
অলপ পঢ়িলেই হ'ব তুমি accidental
গোটেইখিনি পঢ়ি দিওঁ, অকণমান একেবাৰে চুটি।
ঠিক আছে পঢ়া একো নাই।
আমি শিৱসাগৰৰ পৰা
Cross-examination of?
cross-examination of
Claimant.
claimant.
Because only one witness to
Yes,
evidence.
আমি শিৱসাগৰৰ পৰা I-20 কাৰত আহি আছিলো বিয়া খাই আৰু দেৰগাঁৱৰ ওচৰত ৰৈ থকা ট্ৰাকত খুন্দা মাৰে। এক্সিডেণ্টৰ সময়ত বৰষুণ দিছিল। মই আহিবৰ সময়তেই ড্ৰাইভাৰক গাড়ী লাহে লাহে চলাবৰ বাবে কৈছিলোঁ। এক্সিডেণ্টৰ সময়ত গাড়ীখন জোৰত চলাইছিল যদিও নাজানো। মই টোপনিয়াই আছিলোঁ।
This is important, Lordship.
মই চকুত দুখ পাইছিলোঁ।
What she will be doing at 2:45?
No, that's why whether the light, I'm on that the truck
Oh.
did not have a parking light.
But there is no evidence that it had the parking light.
But they have to prove, Lordship. They said, the court is saying that it did not have a parking light.
Court came to this finding.
Yes, this finding.
Well, this may be.
That is why I'm on that cross.
Well, let me complete it.
Okay.
মাজত মানে কি important it.
মই টোপনিয়াই আছিলোঁ। মই চকুত দুখ পাইছিলোঁ। হস্পিটেলত 4-5 দিনমান থাকিলোঁ। মই 28,689 টকাৰ ভাউচাৰ দিছোঁ। মই ডিজেবিলিটি চাৰ্টিফিকেট দিয়া নাই। ড্ৰাইভাৰৰ পৰা গম পালোঁ ট্ৰাকখনৰ ছিগনেল লাইট জ্বলোৱা নাছিল। সত্য নহয় যে ট্ৰাকখনৰ কোনো ভুল নাছিল। পুলিচ কেছ হৈছিল নে নাই নাজানো। সত্য নহয় যে মই বেছি টকা দাবী কৰিছোঁ। Now, cross by OP number 6, that is by my learned friend, Bajaj Alai. ড্ৰাইভাৰে I-20 খন প্ৰথমতে লাহে লাহে চলাইছিল। পিছত কেনেকৈ চলাইছিল নাজানো। এক্সিডেণ্টটো ট্ৰাকখনৰ ৰাস্তাৰ অসাৱধানতাৰে ৰাখি থোৱা কাৰণে হ'ল। ট্ৰাকখন ৰাস্তাত অসাৱধানতাৰে ৰাখি থোৱাৰ কাৰণে হ'ল। ট্ৰাক আৰু ট্ৰাকৰ ড্ৰাইভাৰ এক্সিডেণ্টৰ পিছত পলাল। This is the cross examination.
Truck as well as driver also.
ট্ৰাকৰ ড্ৰাইভাৰ এক্সিডেণ্টৰ পিছত পলাল।
Okay.
But Lordship is accepting she was sleeping. She heard that she heard from the driver that the light was not on. They did not they did not adduce evidence of the driver of I-20 to adduce evidence that the light was not on, Lordship. So, Lordship, on what basis did the tribunal come to the finding that the truck was responsible for the accident? And they are mentioning that it was rash and negligent driving of the truck. Admittedly, the truck was standing.
There may not be driving, but negligence.
The truck was admittedly on a standing position.
It was parked.
It was parked, and she was sleeping.
But it was parked in a no parking zone.
No, Lordship, that has not come.
That is in the evidence.
No.
That was not rebutted.
It is not we have cross-examined, and that is why we have proved that it is not a question. She was sleeping. How does she know that it was in a no parking zone? What is no parking zone on the highway, Lordship?
Entire highway is the no parking zone, unless there are specific allotted places for park.
Base for parking. So they have not said that it was not parked in a bay. And when the I-20 has come from backside, Lordship, that is why we have to, they are not telling the whole truth. We have to imagine, Lordship, the I-20 is coming with a headlight naturally, 2:45 is the time, it must be dark.
No, therefore 40% negligence was attributed.
How come, Lordship?
Some negligence was attributed to, and it is difficult to assess negligence in composite. It is a case of composite negligence, where the claimant may not be in a position to actually adduce evidence.
In fact, it is is not a composite negligence, Lordship. It is totally the I-20 which came and hit the truck. It is not their case that the truck was parked on the middle of the road. They said no parking zone. But the I-20 had its headlight and it came and it came and hit the truck from backside. And no death took place. And the claimant herself is saying that aste solabo disilu, kintu pisot jure solaise jodi, that is, I don't know, na jano, pisot jure solaise je. Aste solabo disilu, then she fell off to sleep, and tapsot na jane je jure solaisil neki. I do not know. So Lordship, that control. And Lordship, 1,50,000 for just 28,000, that is not tenable. And those are my grounds, Lordship. And for his appeal, I'll give reply when he, and our liability, Lordship, 25,000 we have deposited. That will be our total liability, Lordship. That's when it came for admission. That time I had calculated, and that is why we deposited, and they were allowed to release.
How you assess your liability to the extent of 25,000 only?
Because maybe I have the calculation. Let him complete.
You have otherwise deposited 60%.
No, we have deposited 25,000. They have taken it. That order dated 17/7/2019, when it was admitted on that.
Fine. What was directed? 50% of your liability?
No, 25,000.
Specifically 25.
25.
Okay.
And they were allowed to take it. Because that time I submitted that, in fact, we do not have any liability. That's what, even he was present. I said, we do not have any liability, but since we are taking a stay, Lordship, so we will deposit that amount, including the interest.
Okay.
Lordship, I have prepared a short submission, note of submission.
Good.
I just want to go by this only, because it will save time also, my lord. Lordship, the brief fact is that, my lord, the claimant respondent number 1 sustained grievous injuries in a motor vehicle accident which occurred on 3/10/2013. About 13 years back, your lordship. And when the vehicle in which she was traveling collided with a truck bearing registration so-and-so, which had been negligently parked on the national highway during night hours without any signal lights, warning indicators, or barricades. My lord, this I have categorically adduced I have stated in my evidence also. This was not denied. As a result of the accident, the claimant sustained grievous injuries including fracture of nasal bone, multiple facial injuries, injury to the right eye resulting reduced vision, deep cut injuries on the right palm. The claimant underwent prolonged treatment at different hospitals, including Sanjeevani Hospital, Jorhat, Chandraprabha High Hospital, Jorhat, Nemcare Hospital, Gauhati, Meki Eye Hospital, Nepal, Apollo Hospital, Chennai. And to that effect, we have submitted our bills and prescription. And it is not disputed that I had not underwent medical treatment at Jorhat, Guwahati, Nepal, and Chennai and all. As a result of
But
this,
you have submitted bills only to the extent of 20.
I will come to that, my lord. But it is an admitted position that due to the accident, I have to go to the Nepal. I have also went to Chennai also. The learned member MSCT judgment so-and-so awarded compensation 1,70,000 along with interest at 6% per annum. The appellant insurance company has preferred the present appeal, challenging the award, and the claimant has filed a cross objection seeking enhancement of the compensation. Now, in regard to their first ground of appeal, my lord, regarding ground A, medical expenses, which is harping on 28,869. My submission is that the appellant insurance company has contended that the learned member MSCT erred in awarding rupees 1,50,000 towards medical expenses, though the claimant proved medical expenditure of rupees 28,689. In this regard, it is respectfully submitted that the Honorable Supreme Court in Rajkumar versus Ajay Kumar reported in 2011, one SCC held that in routine personal injury cases, compensation will be awarded only under these three heads, my lord. My lord, may kindly see expenses relating to treatment, hospitalization, medicines, transportation, nourishing food, and miscellaneous expenditure. Head B, loss of earning during the period of treatment. That was not awarded. Damages for pain and suffering and trauma as a consequence of injuries. Under D said only 20,000. In the instant case, the claimant had to take medical treatment at various hospitals, including Sanjeevani Hospital, Jorhat, Chandraprabha Eye Hospital, Jorhat, Name Care, Gauhati, Meki Eye Hospital, Nepal, and Apollo Hospital, Chennai. During the course of such prolonged treatment, a substantial expenditure was incurred towards transportation, medicine, hospitalization, nourishing food, and other incidental expenses. Therefore, the contention of the appellant insurance company is, my lord, misconceived and liable to be rejected. My lord may kindly see the judgment. My lord may find, while coming to the figure of 1,50,000, the tribunal has observed in paragraph 18 and 19, my lord, page 14 of their appeal memo, my lord. As specifically,
Yes.
I am reading the paragraph 19. Considering the aforesaid facts and circumstances, and also considering the present cost of medicine as well as other expenses, I am of the view that the lump sum amount of 1,50,000 as medical expenditure, considering the vouchers, bills, etc. submitted by the claimant in this case, is a just and proper amount of compensation here in this case. My lord, the tribunal ought to have, my lord, made three heads, my lord, while passing the judgment, my lord, that I have referred, my lord, A, B, and C, my lord. And here, my lord, under, as per my lord, Rajkumar, my lord, the first head, my lord, that is expenses relating to treatment, hospitalization, medicines, transportation, nourishing food, and miscellaneous expenditure. It's a very broad, my lord, this heading, my lord. So under this head, 1,50,000 was awarded, my lord, because it is an admitted fact that due to the accident, I had to take medical treatment at Jorhat.
Not
Guwahati.
under that head.
What?
Under all three heads, 1,50,000 was awarded.
Yes, yes. All the three heads, my lord. Regarding, my lord, loss of earning during the period of treatment, no, nothing awarded, my lord. Whereas, my lord, it has been held, my lord, annual income is 60,000 in the court by the tribunal. Regarding damages or pain or suffering and trauma as a consequence of injuries, it's a very meager amount was awarded as 25,000, my lord. So, regarding, my lord, ground of negligence, my lord, the appellant has contended that the accident occurred as the vehicle in which the claimant was traveling collided with a stationary truck from behind. So it is respectfully submitted that the accident occurred solely due to the negligent act of the driver of the truck, who had parked the vehicle on the national highway during night hours without any warning, signal, parking light, or barricade, my lord. I have specifically pleaded in my evidence, my lord, to that effect. They have not disputed this, my lord. And section 122 of the MVX, my lord, that prohibits, my lord, leaving a vehicle in a public place in such a position as to cause danger or obstruction to other road users, my lord. 122 of the MVX, my lord. So the evidence of CW1 clearly established that the truck was stationed on the road without any signal lights or barricade, and the said evidence remained unrebutted, my lord, during cross-examination. Therefore, the finding of negligence recorded by the learned tribunal is justified and does not call for any interference, my lord. And they are saying that at the time of accident, she was, my lord, I was sleeping, my lord. Because at that 2:45 I was sleeping, and I have come to know about the negligence part of the truck driver from the driver of the I-20. So now, my lord, also in the cross examination, immediately after the accident, the driver of the truck, he fled away. And this is not my burden, my lord. As per my understanding, my lord, if they are hammering on this, my lord, now in the appeal, they could have bring the I-20 driver or the truck driver to the witness box, my lord, to prove their contention that the truck was not negligent and the driver of the truck was not negligent, my lord. To that effect, my lord, they have did nothing, my lord. Insurance company did nothing. Now, here, my lord, I have preferred the cross appeal, my lord, and in the cross appeal, my lord, what I under the head of my lord, the compensation awarded by learned tribunal is grossly inadequate and does not satisfy the principle of just compensation, my lord. And the Honorable Supreme Court, my lord, in Sidram and versus divisional manager, that was reiterated that the motor accident cases must be, the compensation in motor accident case must be just, fair and reasonable. And here, on certain specific, my lord, head, my lord, no compensation was awarded. And under the head of pain and suffering, amount awarded by the tribunal was 20,000. Which is extremely meager considering the nature of injuries suffered by the claimant, my lord. So, and recently, my lord, in 2020, my lord, Supreme Court in Kajal versus Jagdishan, my lord, in that case, my lord, under the head of, my lord, pain and suffering, my lord, 15 lakhs was awarded. So under this head, at least I am entitled to, my lord, under the head of pain and suffering, I am at least entitled to 5 lakhs, my lord.
On what basis? On what basis?
Because, my lord, I have got the injuries, and as a result of injuries, my lord, I had to taken my treatment at starting from Jorhat, then to Guwahati.
No, on what basis you are quantifying it at 5 lakhs?
No, my lord, because I have sustained injuries, my lord, and injuries have
Then
not been disproved by them, my lord.
why not 3 lakhs or
No, my lord.
8 lakhs?
No, this is my submission, my lord. I am not on that day, my lord may give me 5 lakhs, my lord. This is my, at least minimum, I am entitled, my lord, 5 lakhs, my lord. This is my respectful submission, my lord. My lord will consider, my lord.
No. To consider your submission, I have to first hold that the assessment made by the tribunal is wrong. Tribunal also gave some amount.
Yes, 20,000 tribunal has awarded, my lord.
Why it is wrong?
Because, my lord, it's a very 20, my lord, in regard to my expenditure, my lord. When, my lord, when I have submitted my bill of 28,000, my lord.
Yes.
And that does not include, my lord, transportation, my lord. And naturally, my lord, if a person, my lord, if he is traveling from Golaghat to Jorhat, Jorhat to Guwahati, then to Chennai, then to Apollo, my lord, naturally, my lord, a huge sum of expenditure will cause in regard to transportation. And it's not that only the claimant can travel alone, my lord. So, naturally, my lord, under that head, my lord, 1,50,000 is quite nominal, my lord. Awarding 1,50,000. And, my lord, as due to this pain and suffering, my lord, I have to travel all this. I have to bear. I have to this, my lord. I am suffering, my lord. So considering all these aspects, my lord, my respectful submission is that 20,000, which was awarded by, my lord, the learned tribunal, that must be adequately or enhanced, my lord. That is my respectful submission. It may not be 5 lakhs, but, my lord, it need to be enhanced adequately, my lord. And, my lord, regarding, my lord, loss of income during the treatment, my lord, that is a specific head as per, my lord, Rajkumar and Ajay Kumar, my lord. And under that head, my lord, tribunal has awarded no compensation, my lord. So under that head, my lord, I am entitled some compensation, my lord. Because, my lord, here my lord, the claimant, my lord, she is a homemaker, my lord, housewife, my lord. And recently, my lord, what I have found, my lord, in many judgments, my lord, the homemaker is considered as a skilled labor, my lord. And in the, my lord, I will place the judgment, my lord, in the Kirti and another, my lord, versus Oriental Insurance Company, Supreme Court has held, my lord, that the homemaker can be considered as a, my lord, skill, as a skilled worker, my lord. And he and her compensation need to be considered as per the government, my lord, that notification published by, my lord, issued by, my lord, Labor and Welfare Department, my lord. As per that, my lord, compensation need to be taken, my lord. So my respectful submission is that in Assam, my lord, as per, my lord, this 14/6/2025 notification, my lord, skilled labor monthly compensation is taken as 15,031. So at least, my lord, under the head of, my lord, loss of income during treatment, because admittedly tribunal also held, my lord, due to this treatment 6 months I was under medical treatment. So at least, my lord, 15,000 into 6, my lord, that 90,000 need to be, my lord, awarded under the head of, my lord, loss of income during treatment, my lord. No compensation was awarded under that head, my lord. And regarding, my lord, the interest part, my lord, the tribunal has awarded 6% interest, my lord. So on this, my lord, at least, my lord, 9% may kindly be enhanced, my lord, or suitably it will need to be enhanced, my lord, interest.
Why? What is the basis?
My lord, basis, my lord, Supreme Court in recent judgments also, my lord, the court has taken 9% interest.
No,
And
no.
it was in
I am
the year
not asking
2013, my lord.
on what basis. Basis, there has to be basis of awarding interest.
Yes. So, my lord, I want to refer one judgment, my lord, that is of, my lord.
No, I am not asking for judgment.
Why I'm going to, what is the basis, my lord? I'm coming to that, my lord. My lord, Supreme Court in Kajal versus Jagdishan, my lord, it was of 2000, decided on 5 February 2020, 2024 SCC 413. So in that case, my lord, regarding interest, my lord, court has ultimately granted, my lord, 7.5%. And in that Kajal case also, my lord, it was accident was taken way back in 2013, my lord. So in my case also, it was held in the year 2013, my lord. It was 2000.
No. What I'm asking is, what was the reasoning? We have to follow only the reasoning. What Supreme Court?
Need to be, my lord, as per the banking lending rate, my lord.
Yes.
Banking lending rate. And, my lord, it was accident was of 2013, my lord. So as per banking lending rate, my lord, of 2013, my lord, 9% need to be, my lord, given, my lord.
Have you taken that plea?
My lord?
That at the time when accident occurred?
No, my lord, it was taken at the time of, my lord, this cross objection, my lord. I am claiming 9%, my lord. I was claiming 9%. And here in the cross appeal, my lord may see my grounds, my lord. There I have specifically, I have taken the stand of granting, my lord, 9%, my lord. My lord, ground number 5, my lord. And
Putul cross appeal diyo.
cross appeal, my lord, the ground number 1, my lord. There in the first ground, I have my first ground was, my lord, the learned tribunal.
That regarding interest.
Interest, it's number 5, my lord.
You
And
have
my
not stated the basis. Just you have claimed
yes,
that it is in it.
my submission is that, my lord, it need to be, my lord, given, my lord, as per Supreme Court, my lord, in Upahar tragedy case, my lord. It was as per the, my lord, banking lending rate, my lord. So in the year it was, the accident was occurred on 2013. Claim was filed way back on 3/2/2014. So at
No,
that
suppose
time, my lord,
suppose you are claiming interest at the rate of banking lending rates. Then is it not incumbent on you to produce some material before the tribunal to show that what was the banking lending rate at that point of time? And then if tribunal did not consider the same, then you may agitate it at the appellate stage.
that is there. But my lord, it is not that, my lord, as because tribunal, it's a case, my lord, the matter is of giving just compensation, my lord.
No, you have to assist the tribunal in
No,
assessing the just.
Yes. Regarding that, my lord, I don't know whether such type any judgments on that aspect was placed or not, but regarding interest part, my lord, the judgment is silent, my. Because judgment is silent in regard to the, my lord, Rajkumar, Ajay Kumar case also, my lord. So, which is the, my lord, normally, my lord, in accident cases, my lord, certain heads, under certain heads, my lord, the compensation need to be awarded. And Rajkumar, Ajay Kumar, that judgment is the, my lord, judgment, my lord, on the basis of which, my lord, the tribunal as well as our courts, my lord, follow that, my lord, heads, my lord. So under these three heads, my lord, specific three heads, no such award was granted.
Okay.
So, and regarding, my lord, this ground number, my lord, 4, my lord, that regarding loss of earning during the period of treatment, my lord. So under that head, my lord, some amount need to be enhanced, my lord. No compensation was awarded under that head, my lord. So, and regarding, my lord, this stationary vehicle and all, my lord. Two 2022, 2GLT 1109. So here, my lord, the issue was, my lord, my lord, may kindly see the head note, my lord.
Why you are citing this judgment?
My lord,
To emphasize what point?
for emphasizing that, my lord, standing on the, my lord, road without showing any indicator.
Is a negligent act.
Negligent act, my lord. So, this our coordinate bench of this High Court, my lord, held, my lord, it was a negligent act. So accordingly, in para 15 and 18, it was discussed, my lord, and ultimately held that the, in this case, my lord, in that this cited judgment, my lord, it was held, my lord, the offending vehicle which was, my lord, parked in a highway without proper barricading, without signal light, that was held as a negligence, my lord, or act on the part of the offending vehicle. So to rely on that, my lord, I have placed this judgment. Next one.
Yes.
So in this case also, my lord, the my lord, on the point of, my lord, homemaker, my lord, where I am praying for, at least I need to be granted, my lord, 15,000 compensation as per the government notification, my lord, considering the
What is the evidence
My lord?
before the tribunal? how many days you suffered?
Yes, yes, my lord.
Or how many days you are unable to perform your regular work,
Yes, yes, my lord, I am coming to that, my lord.
even as homemaker?
Yes. My lord, in the paragraph 3 of my evidence in the evidence in affidavit, my lord, I have said, my lord, that about an amount of 1,20,000 was spent for my medical treatment during my course of medical treatment. During my course of medical treatment, number of tests, X-ray, purchase of
No,
medicine.
that aspect is regarding how much expenditure you have incurred. That is to be just substantiated by producing the vouchers.
No,
You
my
have
lord-
produced only 28,000.
No, no, yes.
My
my lord.
query is,
Yes.
even if you assume you to be a homemaker and
Yes,
some loss of earning,
yes, yes, yes.
for how many days you suffered
Yes.
that loss?
Yes.
Yes,
No,
that
3-4 days in hospital in of Jorhat, my lord. My lord, in the judgment, it's of the tribunal, my lord. In the judgment of the tribunal, my lord. There, my lord, I have, there is a specific finding on that, my lord. Accident was occurred on, my lord, 3/10/2013, my lord. So immediately thereafter, my treatment starts, my lord.
From 3/10/13 to
For
17.
3/10/13 to, my lord, 16/14/4/2014, my lord. My lord, more than 6 months, my lord. Because my lord may kindly see the paragraph 18 of my 18 of the judgment, my lord. That is clearly mentioned, my lord.
yes.
Considering my 18, my lord, paragraph 18, page 14, my lord, of the appeal memo. The claimant in her claim petition claimed an amount of 9 lakhs for the injury sustained by her in the motor vehicular accident. Though the claimant in her evidence in affidavit deposed that she spent about 1,20,000 for her medical treatment, including number of tests, X-ray, purchase of medicine, payment of doctor's fees, nursing, cost of attendance, transportation, fooding, etc. But she has submitted the medical expenditure statement, which is exhibited as Exhibit 9 for an amount of rupees 28,689, excluding the, madam may kindly say, excluding the cost of attendance, transportation and fooding, enclosing therein 14 numbers of cash memo and bills, that is of 28,689. In cross-examination by OP number 3, claimant has stated that she has not submitted any disability certificate. From the documents exhibited by the claimants, it reveals that injured claimant took treatment in various hospitals, that is Jorhat, Gauhati, Golaghat, Nepal, Chennai, for the injuries sustained by her in a motor vehicle accident from 3/10/2013 to 14/4/2014, my lord.
No,
It are-
it only shows, suppose you went to, make me more clear on this. You went to Nepal
Yes,
in the month of January 2014.
yes,
Thereafter, you went to Chennai on 14/4/2014. So it does not indicate that you are under continuous treatment in a condition where you could not have
Yes.
performed
Yes,
any
yes.
work.
That's why, my lord, I am not praying for, I am not taking this injury as a grievous one, my lord. I am not praying for that. I am not saying that it's a grievous injury. Otherwise, I would have praised for loss of future earning and all. I am not claiming on that as because I am not considering the injury as grievous, my lord. But my lord, it's an admitted fact, my lord. I was, due to the accident, I was traveling. I was have to take medication. I have to take medical treatment from Golaghat to Chennai, Nepal, my lord, in many places, my lord. So during that period, my lord, if we start from the accident, then my I was returning from that Apollo Hospital on 14/4/2014, and on this point, my lord, they have not cross-examined, my lord. It was an admitted position, my lord. So therefore, my lord, 6 months, considering my injuries, my lord, it's not that, my lord, I am not getting any injury, my lord. I have getting injury and I have to take treatment at many places, my lord. So considering that, my lord, from 3/10/2013, from 14/4/2014, 6 months, minimum at least 6 months, I am entitled for loss of, my lord, income during the period of treatment, my lord. And my lord, this Kirti judgment and my lord, this Kirti judgment talks about this homemaker, my lord. Here, my lord, Supreme Court has held in paragraph 18 of the judgment, my lord. It was a death. It was a death case. Death case. But in that case, the housewife earning is discussed, my lord. And considering that, my lord, the Supreme Court has held, my lord, that tribunal need to consider this as a skill labor and as per the notification of the respective governments, my lord.
Which judgment says that?
My lord, Kirti and another, my lord.
Where? Which paragraph?
17, my lord. I am referring only 3 paragraphs, my lord. Paragraph, my lord.
You come to that paragraph where it has been held.
Paragraph 17, my lord. The second category of cases relates to those situations wherein the court is called upon to determine the income of a non-earning victim, such as a child, a student, or a homemaker.
No, it only says that it is difficult to quantify.
Yes,
in
it is
such case.
difficult to quantify, my lord. I am just pointing out the facts, my lord. First, my lord, 18, then, my lord, 19, my lord, may kindly see the court often follows different principles for determining the compensation towards a non-earning victim in order to arrive at an amount which would be just in the facts and circumstance of the case. Some of these involve the determination of notional income. Whenever notional income is determined in such cases, different consideration and factors are taken into account. For instance, for students, the court often considers the course that they were studying, their academic proficiency, the family background, etc., to determine and fix what they earn in the future. 20. One category of non-earning victims that court are often called upon to calculate the compensation for are homemakers. The granting of compensation for homemakers on a pecuniary basis, as in the present case, has been considered by this court earlier on numerous occasions. A 3-judge bench of this court in Lata Vadha versus State of Bihar, while dealing with compensation for the victims of a fire during function, granted compensation to housewife on the basis of services rendered by them in the house and their age. This court in that case held as follows. So far as the deceased housewife are concerned, in the absence of any data and as the housewives were not earning any income, attempt has been made to determine the compensation on the basis of services rendered by them to the house. On the basis of the age group of the housewives, appropriate multiplier has been applied, but estimation of the value of services rendered to the house by the housewives, which has been arrived at rupees 12,000 per annum in case of some and rupees 10,000 for others, appears to us
12,000 per
grossly
annum.
low. My lord?
12,000 per annum.
No, that was grossly low. That is written, my lord. In the sum and 10,000 for others appears to us to be grossly low. It is true that the claimants who ought to have given data for determination of compensation did not assist in any manner by providing the data for estimating the value of services rendered by such housewives. But even in the absence of such data and taking into consideration the multifarious services rendered by the housewives for managing the entire family, even on a modest estimation should be rupees 3,000 per month and 36,000 per annum. That was discussed in that Lata Badha case, my lord.
It also appears to be low if you,
No. Therefore, my lord, after discussing all this, my lord, the court has held it need to be considered as per the, my lord, considering a skilled labor, it need to be considered as per the government notification issued by the respective
Where?
state government where the accident took place. In Arun Kumar, that was discussed before then 22, before discussing 21, I am reading in Arun Kumar Agarwala versus National Insurance Company, this court, while dealing with the grant of compensation for death of a housewife due to a motor accident, has held as follows. In India, the courts have recognized that the contribution made by the housewife to the house is invaluable and cannot be computed in terms of money. The grossitious services rendered by the wife with true love and affection to the children and her husband and managing the household affairs cannot be equated with the services rendered by others. A wife, mother does not work by the clock. She is in the constant attendance of the family throughout the day and night, unless she is employed and is required to attend the employer's work for particular hours. She takes care of all the requirements of the husbands and children, including cooking of food, washing of clothes, etc. She teaches small children and provide invaluable guidance to them for their future life. A housekeeper or maid servant can do the housework, such as cooking food, washing clothes and utensils, keeping the house clean, etc. But she can never be a substitute for a wife, mother who renders selfless services to her husband and children. It is not possible to quantify any amount in lieu of the services rendered by the wife or mother to family, that is the husband and the children. However, for the purpose of award of compensation to the dependents, some pecuniary estimate has to be made of services of the housewife mother. In this context, the term services is required to be given a broad meaning and must be construed by taking into account the loss of personal care and attention given by the deceased to her children as a mother and her husband as a wife. They are entitled to adequate compensation in lieu of gratuitous services rendered by the deceased. The amount payable to the dependents cannot be diminished on the ground that some close relation like grandmother may volunteer to render some services to the family which the deceased was giving earlier. The above pronouncement has been followed by this court in its recent so-and-so judgment, wherein the national income of deceased wife was calculated for the purpose of granting compensation in a motor accident case. Before discussing this topic further, it is necessary to comment on its gender nature in India. So-and-so census nearly million women household work was in their occupation as a compared. I am coming to that relevant part now.
how to assess the notional income?
I am coming, madam.
Mr. Hajorika, how much time will you take? You have already paid your.
Yes, we have paid money.
We have also paid what we thought that it is correct.
But if the
15%.
appeal goes against you, you have to pay more. And if their cross objection is allowed, you have to even
We reply on that, Lordship.
pay more. So, Mr. Datta,
Yes, madam.
tomorrow, today we are done with time. We don't have time. You come with that. How much notional income can be?
Yes, yes.
She was in hospital for 4 days only, Lordship.
Yes.
7,
No,
10,
4 days in one
13,
hospital.
and no, after that also all outdoor. Her own evidence. I
Let,
took her-
let them continue.
Yes,
When?
tomorrow.
Tomorrow, my lord.
Not tomorrow. On a hearing day,
Tuesday.
Tuesday.
Take much time, my lord. Just I missed the exact.
কালি
voting
কিমান
session,
আছে?
my lord.
Except 19 million. Immediate.
16 I will
No.
not be there.
Huh? Cause this ascent. No, it will be good if we can fix it tomorrow. Then we will not forget.
My lord, I will not take much time, my lord. At minimum, at least, my lord, 5 minutes, my lord. I can complete, my lord. If it can be taken up tomorrow. my
I
lord.
won't question 5 minutes. Maybe I'll need half an hour. नहीं 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 जूनियर बोली भाभी से हाँ, ठीक है
Okay, then tomorrow,
Tomorrow.
before admission, as first item, or at a fixed time, 2.
Well, Lordship, it can be in the morning itself. I have
Admission
cases,
class.
no issue. Two also, no issue.
Or at 12, my lord. Lord.
12 to in
Fixed-
between हो जाएगा.
fixed
At
time or
at
2, my
two-
lord. At 2, my lord.
At 2.
At 12, some case might be going.
Third Miss Adi Chaudhary,
Majumdar.
sorry. Adi Majumdar, learned counsel for the appellant. Also Mr. M. Datta, learned counsel for respondent number 1 and 2, as well as Mr. P. Hajarika,
Correspondent 6.
learned counsel for respondent number 6. The hearing remained inconclusive. List this matter tomorrow as the first item before admission. As the third item as part third matter. As item number 3, we will take it.
Well, I am appearing for respondent number 1.
Item number
1 and 2.
3.
Respondent number 1.
Deeply of.
Hello, pleasure.
May I please, Your Lordship? My lord, I beg to mention item number 17, my lord. So, my lord, in this case, we have some urgency, my lord. It is 2021 matter. The claimant is in, my lord, dying bed, my lord. He may expire at any moment of time. Earlier occasion, the matter has not been, my lord, reached.
Item number?
Item number 17, my lord. So can it be on, my lord, 19, my lord, Thursday?
No, when it can be, only court master can say.
Well, some urgency, that's why I am paying.
19.
Otherwise, my lordship,
19,
it's a hearing day, my lord.
no, hearing day we have other cases.
It's a hearing matter, my lord.
Otherwise on the,
20.
Any date, my lord, as per your lordship convenience, any date, next week, my lord.
twenty-fourth,
24th,
24th of March,
my lord.
24th of March. Due to paucity of time, this matter could not be taken up today. List this matter on 24th of March. Yes, Mr. Murray.
Similar in item number 15 and 16, 2019.
No.
Well, it will be the last part of this month, March. 25, 26, 27, any date.
30 April,
My lord,
30 April,
30,
30 April.
is April.
Yes.
Before that.
No,
it may not be possible.
May I please, your lordship? Your lordship, with respect to item numbers 20 and 29, your lordship. Your lordship, this matter has been pending since 2023 for hearing, your lordship. So I pray your lordship may fix this matter on 31st of March, your lordship, if it's possible, your lordship.
It is not possible, you have seen.
Then your lordship may fix it on 2nd of April. I pray your lordship.
not before Bihu vacation.
Lordship, then 21st of April.
Okay, 21st of April.
Much obliged, Your Lordship.
Similar prayer for item number 14, my lord. After Bihu, my lord, maybe 24th.
30 April. 30 April.
Okay.
My lord, similar prayer in respect to item number 22.
Item number
22.
22. MFE. It is a 24 method,
Yes, ma'am. We need,
12th of May.
my lord, any April date if.
No,
I am
April date.
obliged, much obliged.
Lordship, similar prayer, item number 23. Lordship, kindly fix a date on month of April, 10th of April,
23.
23, item number 23.
Dio. 12th of May.
Nice.